Any mention?
Please, Your Lordship, I beg to mention item number 32 to 35. As the learned Additional Advocate General is on bereavement, Your Lordship.
Who?
Additional Advocate General, Mr. N.D. Shulai, he's on bereavement, Your Lordship.
But he said he's coming back today. He was gone for funeral yesterday.
He's still there, Your Lordship.
Someone else died.
His
32?
35, Your Lordship.
Because of some matters fixed today, he's already given undertaking that he'll be there.
Your Lordship, if it may come up tomorrow.
No, not. Where's the other side?
I'm here, my lord.
32 to 35.
My lord.
Oh. The names. (32) 35. Yes. Any objection?
No objection, my lord.
Okay, yes. Now 2 weeks yes, at the request of Council for State responding. Yes.
Obliged. May it please, lordship. Lordship, I beg to mention item 28, lordship. Item number 28.
28.
Yes, lordship. Lordship, I've already informed the council for the other side.
For respondent 1, 2, 3, 4 on behalf of PS Nobly.
Okay, yes, 2
Let
weeks.
it come after 2 weeks, lordship.
Yes. Yes.
Compliance, lordship.
Wait, please, Your Lordship. Your
Yes.
Lordship, I beg to mention item number 29, Your Lordship. Your Lordship, I'm humbly praying for 2 weeks' time, Your Lordship.
You have objection?
No, man.
2 weeks.
Highly obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 26, Your Lordship.
26. Yes.
Lordship, if the matter may come up after 1 week.
After
1 week, Your Lordship.
1 week.
No objection, Your Lordship.
Yes.
1 week. Yes.
Your Lordship, similar prayer for item
Much
number
obliged,
36 also, Your Lordship.
Number?
36. For the respondent number 2 and 3, Your Lordship, in this case.
For the petition, your lordship.
You have objection?
No objections, lordship.
Yes.
Right, your lordship.
Much obliged.
Yes. Yes.
I'd like to mention item number 13, Your Lordship. Lordship, the opposite side has already filed their affidavit in opposition. We seek time to file a reply, Your Lordship.
13? In the hearing list?
Item
No, you will call it out. You mention that time. The orders have to be passed. Yes.
Please, Lordship, I beg to mention item 30, Your Lordship.
Why keep adjourning this matter?
Lordship, pray for 2 weeks time, 30. The council is from God.
You inform the other side.
I tried to call them, but then.
You inform them first.
Okay.
Supplementary list item number 1.
If no one appears for motion, next time will be dismissed for default when the matter is listed.
Yes, Lordship.
What is this?
Your Lordship, this is the matter for noise pollution, Your Lordship.
Noise pollution?
Yes, Your Lordship.
You
Filed by
made a complaint for the Pollution Control Board.
Yes, Your Lordship.
Where's the complaint?
Annexure 4 is the FIR, Your Lordship. First
FIR?
FIR, yes, Your Lordship.
And
I gave many letter to the concerned authority, that is DCO and Director of Elementary of Education, and lastly, Your Lordship, I filed one FIR to the Lightingwood police station. They came and they investigate the matter, and after that they gave they refer to the pollution board, Your Lordship. Then no result, Your Lordship.
Where is the reference to Pollution Control Board?
24/10/2025.
Where is that?
Page number 20, Lordship.
No, the way they refer to the Pollution Control Board.
Page number 20. 20, Your Lordship.
20 is the This officer inside this is such officer pollution control office.
Yes, Your Lordship. They refer to the.
Have you made them party?
Yes, Your Lordship.
Yes, heard Mr. Mia issue notice returnable in.
Your Lordship, I am here for a simple instruction, Lordship. Please may give a simple instruction to them.
Yes, let them come.
Authorities.
Yes, issue notice Mr. Khan on behalf of the
1, 2, and 4.
1, 2, and 4. Yes, notice was one number 3. What is your grievance? That is noise pollution.
Yes, Your Lordship.
Yes, not.
Yes. And Your Lordship, in the meantime, I need an interim relief, Your Lordship, till the exam is going on, Your Lordship. On 20, Your Lordship, the exam will start, the final exam. So in the meantime, please stop the
You're a
construction.
principal. Who's
Yes,
the
Your Lordship.
principal of a school in the city has made complaints with regard to the construction work being carried out adjacent to the school in question, which has caused dust and noise pollution. Learned Counsel Mr. H. submits that in spite of protests and FIRs filed before the police, which has also since been referred to the pollution to the 1 number 3 Pollution Control Board, no relief has been forthcoming. He therefore prays that let's not beyond that now. Yes, Mr. R. Khan is present on behalf of the respondents 1, 2, and 4. Shall anyone stand counsel Pollution Control Board? Oh, you're standing counsel.
Pollution board.
Yeah, then you accept notice. Something. MSOI Bank, who's present in court, submit that she'll accept notice on behalf of the respondent number 3. Such notice complete. He's directed to obtain instructions by Monday. Yes, on Monday.
Oh, bless you.
Item number 2.
You give copies to all respondents. Yes.
Please, Your Lordship.
Yes.
Lordship, here I'm claiming to the claiming for a post of the PHC, Lordship, in in lieu of land donation. Lordship, here the brief fact of the case is that my father donated a plot of land to the respondent authorities by executing a kacha gift deed, Your Lordship.
By executing a gift deed.
Kacha gift deed, Your Lordship, to construct a water supply and sanitation WSS at Haripur, West Caro Hills. And after the retirement of my father, Your Lordship, I have approached the
time part he was appointed in the school.
In
the
PH department. Yes, Your Lordship. And after retirement, my father was retired in 2024. And after retirement, I have approached the office of respondent number 2 for the same post, Your Lordship. And after that, respondent number 2 has issued a letter dated 6/2 of 2025 to the office of the respondent number 3, whereby directed to prepare and execute a gift deed, a register gift deed, Your Lordship. And after that, Your Lordship, I have registered before the sub-register Tura register gift deed, Your Lordship.
When is it registered?
Is 6/2/2025, Your Lordship.
Where is that?
Page 7, para 5.
No, where's the annexure?
Annexure is Lordship, annexure 7, Your Lordship.
Annexure page?
Annexure 7. Page 27, Your Lordship.
Okay, deed.
And is signed between the petitioner fathers and the department, Your Lordship.
Who has written that that you've gifted conditional gift? Anyway, yes, you heard M.S.M. Rahman, the counsel of the petitioner. You should notice Mr. R. Khan, GA accept on behalf of all respondents. No further notice required. Published after 2 weeks for instructions to affidavit.
Item number 3.
Item 3, 4,
No,
8
where's the
and
petitioner?
item 3, 4, 8, 9, 10 and 13 to 94 are all SOP matters, my lord.
1394.
Yes. 3, 4, 8, 9, 10 and 13 to 94.
Well, 4 and 6 to 10, my lord. 4 is again GNM, my lord.
4.
Item number 4 is
6,
GNM.
4.
Item number 4 is GNM, my lord. 6 to 10 are health department, other employees, my lord.
The regular ones.
My lord.
3 item 4 is ENM.
Yes, my lord.
We'll hear them. We'll do one thing only after the division bench breaks, then we will start these matters.
Yes. But I was only praying that the interim order will pass these matters. Because by the time the matters are heard, judgment is delivered.
So already interim's already been passed.
No, these today's matters, my lord.
They'll be passed, of course. We'll hear the matter today.
Yes, my lord.
Matters are getting listed.
They already listed.
Yes.
Same with the rest these matters. You don't have to move it. The orders are already there. They know what to do now.
Yes.
They can write the order in their sleep also, I think. Yes.
Deeply.
After some time, yes.
Item number 5.
Petitioner was a student of the National Institute of Technology in Shillong.
Yes.
And he passed in the year 2017 after completion his graduation.
Passed in
2017.
Yes,
Page 15 is the degree, my lord.
Yeah. Direction to appoint a petitioner in the post of Gram Sabha. How can you direct for appointment?
No, my lord, I am at annexure 15.
No, I'm looking at a prayer.
No,
how can you direct for appointment?
My lord, in 17.
More direct for consideration, yes.
Yes, that can be, my lord.
No, what is the case?
That is the case, my lord.
Case pending against
my lord, I have said that I have been the student.
Investigation won't come.
My lord, even after
criminal case pending against you, how
even
can you
after 6 years, my lord, the investigation is not over.
Then what can we do? Unless have you filed? What stage is it?
We have to seek instructions on that, your lordship.
Even after 6 years, it is under investigation, my lord.
Yes.
Even after 6 years, it is under investigation. I am not a name accused in the FIR.
We're not here in criminal jurisdiction.
No, my lord, that
yes.
For this purpose also, I am not a name accused. And my lord, my career is at stake now. I am getting the job. I passed the interview, my lord.
But you have to pursue the other remedy for...
That I am pursuing, my lord. That I am pursuing, my lord.
Yes.
But for so far as my career is concerned, my lord, some protection.
Have you filed for quashing the criminal proceeding?
Yes, my lord.
Then you wait for that.
But in the meantime...
Police verification comes, how will you be offered employment? That is a requirement, basic requirement. He has heard Mr. A. Siddiqui, Leonard Counsel for the Senior Counsel assisted by so-and-so with the petitioner issue notice. MST Yang AAG, which was present, as such, no further notice required.
We are appearing for all the respondents.
Required on the respondent stuff. Mr. A. Siddiqui, Senior Counsel, Senior Counsel submits that the prayer petition is for consideration for appointment of the petitioner who, though qualified for the post of Gram Savak, has not been accorded appointment due to the pendency of a criminal case. Is also submitted that you file an application for question.
Yes, for question.
Submitted that the criminal case, the trial, has you not been charge sheeted?
Not yet.
Investigation is still on.
Even after
9 years.
Yes, my lord.
That is
so many years.
It appears from the writ
Then
petition.
you have more chances for the criminal court. Oh no. That the criminal case registered against him has been pending for over 9 years, and this has caused injustice. Yes, for which you file a criminal, you already filed.
Yes, my lord.
For which criminal petition has been filed for quashing.
That part has not been mentioned here, Your Lordship.
Yes?
That part is not mentioned in the writ
Mentioned,
petition.
my lord. How is it not mentioned?
I have not
We have
seen
given enclosed a copy of the order of the.
only the bail order I've seen, Your Lordship. Order of bail of 2019.
Para 7, my lord, please see how this
Okay.
allegation was brought.
An
back.
extra 10 is there.
Anyway,
Yes.
yes, sir. What can you list after 3 weeks? You pursue the criminal petition.
Yes.
Oblige, Your Lordship.
Yes.
Item 11.
Wait, please, Your Lordship. Lordship, this is the second round of litigation filed by the petitioners, Lordship.
Yes.
Praying for Lordship the giving the equal rank of the Hindi translators. They
are
equal.
Who are the petitioners?
Petitioners are the Hindi translators, Lordship.
Any translators?
Hindi
Okay.
translators.
What happened?
They are working in the Assam Rifles. They were initially appointed Hindi translators, which is a civilian post, Lordship. Subsequently, it was combatized, and the rank of Naib Subedar was given. But Lordship, at that time that they represented that Naib Subedar in other central military force, armed forces, polices.
Who's that? Yes.
The entry-level Hindi translator, their high scale is high, so they stated and they prayed that they should be given equivalent rank, status and pay. So they approached the Honorable High Court. They were not given, they approached the Honorable High Court. At page 58 is the order of the Honorable High Court.
So they given that warrant officer.
Lordship.
Page 50.
58, Lordship.
58.
58. Page 58 is the Honorable High Court's order dated 12/4/2019.
Yeah.
This is
yes.
That Lordship, the paragraph 1, that mean Lordship may come to directly to paragraph 9, page 60.
Yes.
Honorable Court observed, the observation of the Honorable Court, learned counsel for the petitioners has rightly projected that the disparity in rank, pay and status of the Hindi translator of Assam Rifles as compared to Hindi translators in BSF, CRPF and ITBP is quite evident. The job profile of the Hindi translator is same, post is same, therefore disparity offends the rule of parity which has effect demoralization. Then Lordship may come to paragraph 12, page 61. May I read, Lordship?
Yes.
The petitioners cannot be deprived of projecting their rights when the infringement is apparent.
So after what happened? You
After
given
that,
that
yes,
rank and
it was observed. Then they were directed to file a representation
yeah,
to
then
the
what happened?
authorities.
You were given your
Yes, authorities were directed to consider their case along with the recruitment
rank,
rules of
status and pay you got.
Lordship.
You got the rank, status and pay as paid.
Yes,
Yeah, then what happened?
They admitted that there is disparity.
Yes.
But they have given us the equal rank of status of Subedar, that equivalent to the inspector of other CAPF with prospective effect, Lordship. So my now
You want from date of enrollment?
Not, yes, we have for enrollment. So
Yes, Dr. Mojika.
Allow me to file affidavit.
Yes, I heard your name?
A.R. Tohbildar, Lordship.
A.R.
Tohbildar.
Tohbildar. Heard Ms. April under council petition issue notice. Dr. N. Mujika assisted by
C. Jala. C. Jala.
Assisted by MS C. Jala is present. Such no further notice required under respondents. This also 3 weeks. Substance affidavit.
Lordship. Obliged, Lordship.
Yeah.
Item number 12.
Yes.
Your Lordship, this miscase 15.
Yes.
Yes, Your Lordship, the application pertains. I am seeking leave from this honorable court.
File review.
Petition, Your Lordship.
Why?
Yes, Your Lordship.
Where?
Your Lordship, the respondent number 6 actually has played fraud upon this honorable court by suppressing material fact, not making me a party wherein a case of succession is pending before the district judge at Southwest Garo Hills, Sampati.
Where is the order?
And
Order is seeking review.
It's 27.
Of the
page 27.
Of the review application.
Of the main review application.
Main review application.
Yes. Hate fraud.
Yes, it's played fraud.
Okay.
Your Lordship, page 27, Your Lordship, is the order.
1 second. Yes. Oh. Who appeared for response number 6? Number 6 is.
Mr. Sheikh had appeared, Your Lordship.
How come not recorded in the order? Oh, Mr. Sheikh is the petitioner.
Para 2. His name is mentioned, my lord.
Where?
Para 2. As nothing remains for consideration, Mr. S.A. Sheikh, Lord Counsel also.
Okay. Oh. Yes, you what?
I'm for the state, but it appears there was no adjudication as such. So the question of error apparent does not arise. It was closed as being infructuous. Please see para 1 of that order.
Where's Ailingwa? Yes.
Since the payment was released to the petitioner, it was closed as being infructuous. There was no adjudication.
Your Lordship may come to page 11, Your Lordship, annexure 1.
You mean the petitioner suppress the entire fact about pendency of succession over succession case?
Yes, Your Lordship. This is annexure 1, page 11, Your Lordship.
Yes.
This is the application filed by the petitioner in the year 2020, Your Lordship, which is still pending before the district judge, Southwest Garrowes. Now, the
Yes, do one thing. We'll list it again next week. Call for the records of WC number 409/2024. Yes, Miss Kiri.
Your Lordship, there is a delay of 2-1.
No, let us examine it first. Let's examine it first whether your review is maintainable or not. Since there's no adjudication as submitted, Miss Review Petition 15/2025. Stop. This is an application seeking leave to file review application against the judgment order dated 11/3/2025 pass in WC 409/2024. Stop. Before taking up the matter of consideration, it appears that the records of WC 409/22 since disposed be requisition to be placed before this court next date, just after 1 week.
Deeply obliged, Your Lordship.
Yes.
Daily list item number 1.
There are 2 cases.
One is the appeal filed by the union, 2 is the appeal filed by.
Is this it today also?
Yes, my lord, item number 3.
What's it for?
I had filed an application for amendment of the memo of appeal, my lord.
Where's that application?
Sorry, listed.
Like second one.
Item number 3.
Item number 3. So this is 1 and 3 are together.
Yes, my lord. Against the common order, one is our union's appeal, my lord.
One is your appeal.
Yes.
FA number 9 is your appeal, and article.
Number 3 is mine, FA 6, and the miscase is MCFA 31. 13.
You have any objection to the amendment? Amendment of a correction?
It's an amendment, Velas, because in my original prayer, I have left out a particular miscase.
What to do? Your objection?
I'll not object to it.
Huh?
That will be allowed.
Yes, an application file under Order 4123 CPC for amendment of the memo of appeal. Stop.
This is 6. Second one, other case.
Mr. S.N. Leonard, counsel for the appellant, submitted that in the memo of appeal that has been filed. What has been left out?
The cost title, in the cost title, I ought to have mentioned arbitration case number 96 T of 2003 and arbitration miscase number 102 T of 2003.
The council submits that in the course title certain in the course title arbitration
Miscase 102 T of 2003 has been left out, including the prayer as well.
Yes, submits that the operative and executive part order pass in arbitration miscase 102 bracket T 2003 has been has not been mentioned, and as such amendment to course title appeals the prayer to incorporate the said arbitration miscase 102.
Yes, sir.
T is required. Stop. The councils also drawn the attention of the court to para 5, 1 and 2, wherein the amendments sought to be made have been illustrated. Dr. N. Musica, learned DSGI, have no objections to the amendments sought to be made. You will file a fresh memo of appeal.
We can file it if your lordship is direct. Immediately we'll file it.
Yes. The appellant is Mr. Miscase is allowed. The appellant is to file a corrected memo of appeal within
2 weeks, minute.
Within 2 weeks. Yes, thereafter.
Gotcha.
Yes, and the main case list after 2 weeks. Yes.
Highly obliged.
In view of the order of so and so, this after 2 weeks for filing of amended memo of appeal in this FA number 6.
6.
FA 9 list together with FA 6.
Obliged.
Item number 2.
We'll break now and then we'll come back. Well, we can take up your matter earlier.
Any mention? Supplementary list, item number 1.
The election hearing? This is which one?
It's an income tax appeal, Lordship.
Which matter is this?
Lordship, this appeal is filed under
Supplementary list is wine dealers, Lordship.
And this admission hearing, you are appearing in admission hearing matter? That SS Netcom? Who's for the... You're for the respondent or you're for the appellant, huh?
I'm for the appellant, Lordship.
Okay. Where's Mr. Kyle?
Lordship, he has some personal difficulties, so he is Guwahati, Lordship.
You ready to matter today?
Lordship, can hear me?
Yes. Actually, you should hear for the admission hearing.
Lordship, if I may interfere, Lordship.
Yes. Yes.
Lordship, as per the last order, the substantial question of law is to be framed, your Lordship.
Okay, yes. I think we'll take up this main list first. Yes. Yes. Admission hearing. If it submitted, they would have brought it on notice. Oh yes. By SS. What about income tax? Or what about your respondent?
Lordship, as per earlier order, your Lordship, an advance copy was directed to be served upon me, your Lordship. That was never served, your Lordship.
I have not received anything, my lord.
Now you see this one. Anyway, you do one thing. This one also you can't make out the signature, nothing by whom. It's just a one piece of paper.
Lordship.
This is by you.
This is my local council, Lordship.
Who's the local council?
Lordship, Shankar Pandey, Lordship.
Where is he? At least, no, there's no signature. This was filed by you, Mr. Pandey.
Lordship.
Substantial question of law. Was it filed by you?
Lordship,
on behalf of the appellant?
Lordship, these are suggested.
No, this was filed by you.
Lordship, we have filed.
Where is the signature?
Lordship,
does the advocate file like this? Just throw a piece of paper.
Lordship, I'll amend it.
Please file in proper form. Yes, the appellant is directed to file the suggested substantial questions of law in proper form, stock with advance copy to the respondent, who shall also file the substantial questions before the next date. By the next date, yes. Based on?
After 2 weeks, Lordship.
After 2 weeks, yes.
Item number 2.
No, Lordship.
Obliged, Lordship.
Oh, they are.
Your Lordship, in this matter, they have filed an application regarding the maintainability of the appeal. Lordship, in this matter, I required 2 weeks time to file my reply because they have challenged that the appeal is not filed within the time. The appeal was not filed within the time.
Yes.
That maintainability has been challenged. So,
Yes.
so Lordship, I required 2 weeks time to file my reply.
Yes, you're Mr.
K. Jain.
Mr. K. Jain, the General Counsel for the appellant, please be allowed to file a reply to the objection on the maintainability of the appeal. Yes. Yes, up. Objection or rejoinder?
Rejoinder, Lordship.
Make
Rejoinder,
correction,
Lordship.
yes.
We have filed the affidavit,
Yes.
Lordship.
Rejoinder affidavit, yes.
Much of.
Item number 3.
No, sorry. Objection to supplementary.
Lordship, there's a defect in my miscase application, so I may be just allowed to withdraw a file afresh because there's some defect in my miscase application for condition of delay.
Is in order?
Yes, it is in order. So actually,
you already filed objection, and why you want to withdraw it now?
They have filed it under wrong provision of law, my lord.
What provision of law?
Actually, it's up in the Limitation Act, Section 5 of the
Continuation of delay,
Limitation.
they have filed it under Chapter 3, Rule 4, my lord.
Is it due to what
Doesn't matter, overlook nomenclature. How many delays is there? 1645 delays?
Yes.
Plus 5. Ready with to argue?
Yes, if lordship
We don't look
is-
substantively that 1645 days delay is there. Right? Instead of withdrawing and filing again. Easier. Easier, I know. We don't have that. So, yeah. They have been that much. 645 Yes. No, but it is also another spirit. Not limitation. See, in this case, limitation will not apply, but you have to show why reasonable cause as to why, sufficient cause as to why you come out to 1645 days.
Yes, the reason I have stated, your lordship, that is only because of non-communication. The earlier, the person who has been pursuing this matter before the division bench, lordship, that person actually prior to the disposal of the writ appeal, he
Submit from
expired.
application, not from just what is the reason for delay? Now, when was the order passed?
The order was passed on the lordship. It was on the 09/02/2021. That is it.
21.
Yes.
Okay. The earlier appeal is dismissed.
Earlier appeal was disposed of, so we are filing.
No, yes. 21.
Yes.
Now you say that you want to file for review of the
Yes,
this order,
of that.
right? So, notwithstanding any condemnation, I think you have to satisfy this court in entertaining the review application that you were prevented by sufficient cause. Because why the delay? You explain. What's the delay? Why was the delay caused?
Yes. The delay, my lord, on that only thing is that I have mentioned in para page 4.
So you say you take shelter of COVID.
Yes.
As per your thing. Yes.
Then after the COVID, lordship, my another ground is that there's non-communication because
non-communication of what?
That person who has been pursuing this and the writ appeal, he expired during the pendency of the writ appeal, and the writ appeal was disposed of.
Where did he expire? Where's the
expired, lordship? I think, yes, there is a.
Who was pursuing the writ appeal?
Was pursued by late Gronot. Now it's a wife is pursued.
The records earlier petition are here.
Yes, lordship.
The records earlier dismissed. Yes. There is who filed the appeal? And who was the writ petitioner?
Writ petitioner is both a husband and wife. This one, page 111, my lord.
Of your memo
yes,
appeal?
Memo
of your
appeal.
review application?
Yes.
111, okay.
111.
Yeah. The memo
posted.
111.
111.
No. I'm talking about the writ petition.
You the petition.
Where is the writ petition? Page. It's next year review application.
Yes.
No, it's not annex.
Let's just trace the chronological sequence of this.
Lordship, writ petition is not enclosed.
They are not enclosed, madam.
Only the writ appeal is enclosed.
Okay.
In the writ appeal, there
So,
will be petition also, sir.
But in the writ appeal.
So You were, that's what I'm to say. So in the writ petition, you were respondent number 1 and 2.
Yes, Lordship.
Okay. In the writ petition, you were.
Writ petition would be page 122, Manu.
No, it's that we just want to get array of parties.
What?
That would be C, that is 389.
389, yeah. That is page 122.
1 second. 204. Now you are the now the review petitioner, or now the writ appellant is respondent 1 and 2.
That's
okay. Now this is allowed. Now you have made a Nokma of Sasad Gray. Okay. Against that, you file the writ appeal. This is order. The order. Order single judges.
Yes.
2010.
Yes.
29.
29/11/2010, my lord.
Okay. 29/11/2010. Now appeal preferred. Appeal was preferred in 2012.
Yes.
Okay. 2012. That means appeal number 39.
39 of 2012.
Of 12. And this was disposed of on 9/2/2021.
29/11. No,
9/2/2021. 21. Now in the writ appeal, oh yes, limitation. You have limitation. No, you take the whole review. No, we just relax. Yeah. See, Mr. Sangma, how are you aggrieved now? See, the finding of the single judge as also the order appeal which you seek to file review. Now you come to para 4 of your
Lordship,
judgment you seek review with.
On merit, your lordship, I will.
We have to do on merit because the thing is that we're not looking at a nomenclature. We have see the thing is the delay maybe will condone because.
Yes.
Another condemnation, reasonable explanation has been. We'll see that maybe you have been caused by sufficient cause has been. We have objections to that, of course, but we'll examine the appeal. There's nothing in the
Lordship. I will on today because I thought maybe only because of a condemnation case.
You
But
come to para 4 impugn. Come to para 4 of the judgment you seek to review.
I will argue on merit on the next one. Just give me some accommodation because I was thinking basically I prepare only on the application of condemnation because that one only I have prepared. On merit, lordship, I have not prepared honestly. So I am seeking accommodation. So I will argue on merit, your lordship, on the next case without fail, lordship. I need some time to prepare just to accommodate
two orders. You just see 48, 1947
Because
and
if I
27, 1952.
Yes, I've
Yes,
got-
then what now? How can we? How can you seek any?
Yes, therefore I'm asking some just for the interest of justice, seeking some time accommodate to me to only to argue on merit.
Okay, yes. Next week,
Lordship.
yes, on the prayer, Mr. P.T. Sangma, learned counsel for the review petitioner. This matter next week, yes.
Hello, much blessed, Lordship.
Supplementary list item number 1.
Some judgments are.
Lordship, please.
Where's the Karwanang? What are we doing the division bench sitting?
This is the comparative chart, my lord, that you were asking on the last occasion about the difference of price and the profit that we are supposed to earn prior to 12th of September 2025 and after that. Your lordships wanted to know what is the profit margin of.
So what's first one?
Yes, now we'll stick to the first one because these are the what we have annexed with the affidavit. The first one, my lord, is the MRP is 480, which is the present one, with profit margin of 80 rupees with 20%.
Yeah.
The profit margin as of 15% will be 63. So the profit per bottle will be 63. Like that, my lord, there are other brands like Blender's Pride, which is also 750 ml, which is the 761 price. We used to make 127 prior.
Okay, now we get the idea.
Yeah, that's what I believe your lordships wanted.
Yes, only one thing with the Attorney General.
Yes, ma'am.
They say that they have been compelled to sell at the new rate without the scheme going live.
Yes.
How do you answer that?
Yes, no, my lord. If your lordship will see, the scheme is live from 1st October of this year, my lord. The scheme is live, my lord. Now
Then if you haven't given us scanners, how will the factor
no,
in
my
the
lord,
prices?
if there are two things, my lord. The prayer before your lordship is to the virus of the regulations. That's saying that the regulations and the amendment is bad in law, my lord. So now their second grievance is that the implementation, there are problems in implementation and they do not have scanners, etc. my lord. That is what the implementation part of the regulation. First part, your lordship, is that they were questioning our power to have those things. Now they have given up. Now they are saying that they are facing some difficulties in implementation part, that they do not have a scanner, my lord. Now for that, my lord, we have, if your lordship will, the data which the additional affidavit they have filed, kindly see the additional affidavit, what they say in the additional affidavit, because the whatever they say orally, sometimes they do, it doesn't match with the additional affidavit, because in writ all these issues are not there. They are trying to build a new case in the additional affidavit. My difficulty is every time when I file reply counter affidavit, they give up all their case in writ petition. In additional affidavit, they come out with a new case, my lord. That is the problem which I face all the time, my lord. Because if they have, my reply was very clear, my lord. Now they say, however, shockingly, till date, the hardware and scanning have not been provided to any retailers, and despite, I am reading paragraph 3, my lord.
Yes.
Yes, my lord. They all are required to register themselves in the system, and which is to be introduced by the respondent authority. The hardware for the system will not be procured by the stakeholder. It has to be provided by implementing agency on behalf of excise department. However, shockingly, till date, hardware and scanning devices have not been provided to any retailers, and despite this, retailers are being forced to sell new stock as per the new rates. Extraction of revenue is expressly illegal. So, in this paragraph, there are two issues which my friend is raising. One is saying that without the scanner, they can't have the new price.
Yes.
Yeah, that is what they are saying, my lord. Scanner.
So they refer something somewhere else where this notification saying where it goes live. Where is that?
It's in the.
Now, if you lordship will see, my lord, this is the
whatever
main
it is, we can expand the scope, Mr. Archival General.
Yeah, I bow down, my lord.
Might be amendments under challenge.
Yes, my lord.
But the manner in which if they are facing difficulty, that means your act is is faulty.
No, my lord, if somebody will come, with greatest respect, my lord,
amendment in place,
no, my lord, somebody will come and say that we are facing difficulty, my lord, that is not good enough, my lord. At least they should have some material. What is the difficulty? They are lying on the oath when they are themselves registered, my lord. They are saying it is system is not live and they are registered, my lord. Even petitioner is registered, my lord. Now what do I do when they come and lie on the oath? My lord, I am not coming, sir. Your lordship will expand the scope. But ultimately, they have to produce the material. What is the material they are producing before your lordship? And if this give me opportunity to file, because they are saying they cannot sell it without the scanner is being provided. What is the hindrance? The rate is there, price is there. They can sell it. How scanner is relevant?
They are paying, their profit is being deducted.
No,
in effect, this new system which you're putting in place, where you can track every bottle of alcohol in its entire travel,
that is what
from the manufacturers to the central bonded warehouse to the bonded warehouse to the retailers. Now, if your argument is that you leave it aside and you go by the MRP printed in the price, then why do you put a scheme in place at the first place? You just tell them straight, look, we are reducing your profit margin from 20 to 15%, and give the new MRP. You say new MRP, you take 15% of the profit from there. Then why should you go to elaborate exercise of saying, we're putting this barcode, we're putting the sticker, one entity or one service, one provider or vendor will give this, other one will give a barcode, and then we'll give the scanners. Why are you going to all this?
My lord.
So like a packet of biscuits, you sell it, it's 10 rupees, 10 rupees.
There are two challenges before your lordship. There are two challenges. May I simplify?
So at least make us understand as to what this whole scheme means.
Yes, my lord.
And what is go live.
That is why I wanted your lordship to go to the main matter, core matter. If your lordship will hear the core matter, all these issues will get resolved. If your lordship will hear the core matter, core issue is, my lord, that we are implementing excise management integrated system.
Right.
Yes.
Exactly.
Now it has got two components, my lord, and that system is under challenge in the writ petition, my lord, and they are also challenging the reduction in their margin. There are two challenges, my lord. There are two
Let's try to understand.
Yes, my lord.
You're putting this tracking system, correct?
Yes, my lord.
Which is composed of two components.
Yes, ma'am.
In tracking, number one. Now, in implementing this scheme, you are putting the burden to implement on them by reducing that
No, not at all, my lord. Not at all. It is a false statement. Because our regulation itself says that everything will be borne by distiller, not by the distributor.
So that 20% is not affected?
No, 20% is a separate issue, my lord. That is a margin which we have reduced across the board for everyone.
So they are not bearing the cost for implementation?
No, they are not bearing. I kindly see their notification.
That is very confusing.
No, my lord, kindly see one page only. Because they are creating
it together.
No, that is why that's why they don't have case. They are confusing because if you have a grievance with regard to margin, you should have filed separate writ petition. You have grievance with regard to implementation of integrated both these are two. And if you will see my counter affidavit notification, kindly see the notification, my lord. First page 45, and I will show their prayer also, my lord. They are creating confusion, unfortunately. Page 45 is the statutory notification issued under rules section 36, my lord.
Yes.
And at page 46, my lord.
Yes.
Your lordship will see this is the rule which has been inserted. 378, my lord.
Yes.
Integrated excise management system. An online end-to-end integrated excise management system cum track and trace solution shall be set up in the state, which shall include the facility of automation of excise functionalities of all liquor bottles with QR codes based on hologram, besides other modules for real monitoring. All distilleries, breweries, bottling plants, central bonded warehouse shall install requisite track and trace hardware and software.
Fine.
And kindly come to the cost part 9, my lord. 9.
Yes.
The cost of implementation as effected from time to time for both software and hardware shall be borne by distiller and bureaus and bottling plants and companies and added to their cost by separate.
And where is the other 20%?
Now if your lordship will kindly see the prayer.
Now come to the other part.
Yes, my lord, that my friend is annexed, my lord, that your lordship will find notification at page 79
of this
of the writ petition.
Now it's getting some light. Otherwise,
yes, my lord, because that's I'm also confused, my lord. I'm so confused. What do I do? Sometimes the unrelated cause of actions are there, my lord.
No, if it's unrelated to anyway, we see.
Yes, my lord.
Now where we see?
Not, your lordship will see page 79 of the writ petition. This notification is under challenge. This is under, my lord. Kindly see, both are different provisions, my lord. If your lordship has seen the other one,
378.
yes, my lord. And then in power exercised by section 36, read with section 21 of Meghalaya Excise Act, the governor of Meghalaya is pleased to make the following rules for further amend the Meghalaya Excise rules, Assam Excise rules, hereinafter referred as rules, my lord. And then your lordship will kindly come to the page 81, amendment.
Yes.
Now, the kind of liquor and maximum percentage of profit margin be revised on retail sale as shown below. The maximum percentage is 15%. So it is.
So it's not linked at all.
It is not linked at all. These are two different.
All along, Mr. Fu, you are under impression
yes,
that the reduction in your profit margin
yes,
is to facilitate the servicing of the costs for this tracking of this.
No, my lord, that's not my writ petition at all. I'll clarify once my learned counsel.
Anyway,
yes, so therefore, my lord, now kindly see what is their challenge. Please see their challenge at page 35, because we are now additional affidavit. They can say too many things, but ultimately it is the prayer in the writ petition which will govern. And if they want to expand, I have no objection. I will answer all queries, my lord. The lordship will see a writ in the nature of certiorari, page 35 of the writ petition. Writ in the nature of certiorari ought not to be issued to set aside the impugned letter bearing number 13th August 2025, my lord. That notice, then your lordship, a writ of nature of certiorari ought not to be issued to set aside impugned letter of 12/9/2025. A writ in the nature of certiorari ought not to be issued to set aside impugned notification bearing number 12 September 2025. A writ shall not be issued authority to refix maximum retail profit. And writ of direction, my lord, I have shown that integrated management excise system is not under challenge. That integrated management excise system rule is not under challenge. So without there being any challenge to rule, my lord, I am on the first part. On integrated management excise system rules. So, your lordship, kindly take note of the fact that my rule by which.
Yes. Yes.
Kindly take note of the fact that rule by which integrated management excise system has been reduced is not under challenge.
They've impugned the letter.
And they have impugned the letter. That is one. Now kindly see what is the crux of those letters also. My lord, it will cut the clutter. Kindly see 65.
66.
66 type copy.
Yes. Yes. Yes.
Now this is the cost card. Your lordship has noticed in rule 9 cost card discussion about the cost card, because cost will be added to the cost card in rule 9 of integrated management.
There's two components, 240 and 150.
Yes, my lord. So cost card is to be borne by distributors, not by wine dealers, not by dealers, my lord. That cost card will be part of the MRP, my lord, and they are not bearing the cost, my lord. I have placed two agreement of Himachal and the other Assam also. They have got identical system. Two agreement also I have placed, my lord. So ultimately they are challenging the vires of the notifications. Rule they are not challenging, my lord. The basic parent act under which these have been framed. Because we are now, my lord, dealing with the hologram, all those things. Now their notification is under challenge. Kindly see this notification, my lord, page 66.
6 is the letter.
Yes, letter. This is the letter which they challenge. With reference to the above, this is to inform you that department has signed an agreement with CMP for implementation of IEM QR code level in Meghalaya. In this connection, the department has fixed cost of IEMS application at the rate of 240 and GST plus hologram 50 paisa. It is this you are to submit the cost card accordingly. So this letter is, my lord, addressed to whom? It is not disclosed here, my lord. This letter is addressed to whom? This is the cost card is at the level of, my lord,
This is addressed to whom?
This is by to distillers, distributors. If you, Lordship, kindly come back to the rule 45.
No, section 9 is strange. Now, this is not a memo, it's not an executive order.
Yes, my lord.
It is not, is sort of a letter.
I will have to.
Who was it informing?
No, we are informing to the because it
where's
is
the covering letter of this one then?
They have. I will place the entire correspondence on this, my lord. It's better, my lord. I will place the entire file how it has taken place, my lord.
You place the file?
Yes, I will place the relevant notifications and everything on this point, my lord. I will place everything, my lord. And then the core issue is, my lord, core issue is that integrated management excise system, which we have introduced by the rules, is bad in law or not, is beyond my power under Excise Act or not. Because that is the core issue. If I have the power, my lord, and they have some grievance with implementation, that representation, we can look into this, we can resolve it, my lord, because there could be possible. I am not saying that there will be no issues. There will be issues which we have to resolve it. We are not saying that we will not help them or assist them in if they have problem, but they make a general statement, and when we have system at large scale, there will be some teething problem initially, my lord. That I can't deny, and as a state I can't serve my responsibility. But that is not the basis to strike down the entire system when we are trying to have proper non-spurious legal.
The question of striking the system is like
because they are praying. I know.
Whether you see, we were under the impression, or rather, that that this cost was being extracted from the retailers, that resulted in the reduction of their profits. Now there have been twofold. One fold is that they are against the implementation because it has not gone live, and they are forced to sell at the new rates. So now your submission is that these new rates are factoring the 15% only.
Yes, my lord.
And the 80 rupees, the other, suppose in what they've shown, where's the chart?
That your lordship will 65, page 65.
No, the chart, where's the chart that?
68.
No, the chart here. Just
81, page 81, my lord, chart.
No, 1 second.
This is this is a chart. I don't know what do I do with the chart, my lord. I don't have instruction, nothing. Suddenly you hand over the chart.
It's just that. See, now we just make the court understand, right?
Yes.
Now, when suppose this is was Royal Stag Deluxe whiskey, 750 ml. Now the MRP now is 480, right? And then profit margin as per 20%
is 80
rupees.
Correct.
And now 63 rupees.
Yes, my lord.
Right.
Yes.
Now increasing this MRP on the bottle, that is without your scheme going live. How is that possible? Just for our understanding.
No, I understand, my lord. The question is, my lord, for MRP will include the cost, the 240 paisa.
Exactly.
MRP will include.
If we have not gone live now.
No, because now, my lord, MRP will include it has gone live.
No, MRP will include a 240 plus 150.
240 paisa, where MRP will include 240 paisa of the hologram. There is no issue on that. Now, my friend's grievance is that now he is getting 63 rupees in place of 80.
Yes.
Earlier he was getting, because 20% margin was maximum margin, he says that was the maximum permissible margin which my friend's client could have got it. That is the maximum permissible. Now my friends, it has 17 rupees, it has come down. My lord, now the question is whether they are entitled to 17 rupees, whether they can have lesser margin, more margin, whether the state has power to fix the margin or not. This is the moot question before your lordship in this writ petition. Because ultimately, if the fixation of margin is their case is, what I understand, that the fixation of margin of 15% is arbitrary, and 20% which was fixed earlier, that margin should always remain 20%. That is their case. They're questioning the state's power to fix the margin. So that is the fundamental.
Let's see what he has to say.
Yes.
Mr. Now what you heard, now they say that it's totally two different.
I'll just first clarify whatever. Yes, I'll first try to clear this confusion, my lord. Yes. If your lordships remember, the first day I said, I am not against the system. The very first day, my lord, I said, I am not against the system. There is an amendment to an act. The amendment has led to a notification. The notification says that by implementing a scheme under the Excise Act, by this amendment, I am going to reduce your profit, which was initially 20%, has now come to 15%. So nowhere in my writ petition, I have said this, that you are going to extract this amount for implementation of scheme from me. That is not my case, my lord, and I'm making it extremely clear, not a single averment. So first thing stands very clear. I am not here saying whether the state has the power. State has the power. There is no problem on that front. We have not disputed at any stage. All I'm saying, if a scheme has to be introduced, the scheme has to be introduced in a uniformity. You want to take money from somebody, take it from the customer. Why are you taking my profit, where a business has already been subsidized to a larger extent, where the profit is anyway being gone? So, my lord, I'm making it extremely clear from day one, I am not against the system. And I repeat again, and I'm making it extremely clear. Enhancing the scope, this is a process. I am saying, my lord, if you want to introduce a scheme by this way, forcing it on me, that no, 15% will reduce. I am not saying this 15% is going, that they are implementing it for the scheme. They are not taking a single money from me. I have said it in my affidavit. Not a single money. The scheme is to be introduced by the department, pass it on to the manufacturer, and it falls down. I am only supposed to sell. I have no other role. I am scanning it, selling it. Now the question is, can it be done in a manner like this without even notifying? Now my learned made a statement, it has gone live on October. I want to say how. How has it gone live on October? Till date, there is not even a single instance put forward by him to say that it has gone live. If it is a trial and error, no problem. Any scheme, my lord, introduced under any act can always go on a trial and error. I have no problems. But to say that a scheme has gone live is contradicting my affidavit. Then he has to come up with something.
Still maintain that as per, the link is there.
Yes.
Between the reduction of profits and implementing the scheme.
I will explain to your lordships why he's saying that. I'll tell you why.
No, that is your submission also.
Yes, my submission is...
per se, no. But then by, a convoluted way, that they are taking 5% profit from you is to implement the scheme. That is what we are getting.
It is indirectly trying to give.
Indirectly, yes.
Indirectly taking the money from me and giving it to somebody who's introducing the scheme. That you can't do under the Act. So you are going on a reversible situation, my lord, under the Act.
Yes, that is what the case.
So therefore I am saying, my lord, that the introduction of the scheme is no problem. But what you are doing is taking my profit and using it for implementation. That you can't do it. That's nowhere in the Act. So the amendment is theirs. It is absolutely right.
Can we look behind lift the veil such an extent that, we have an inquiry into the what do you call it, the revenue stream?
My lord, there's something more to that. I'll tell you, lordship, what has happened. In excise, my lord, these are only to be implemented and extracted from a manufacturer. So the question of me or somebody, there's no question about it. It doesn't fall on me at all. This is excise. So it doesn't fall on me. I am only supposed to implement what is given by the government. I am not doubting their capabilities to implement something. They have the power under the Act.
No, of course, they have the power.
So there's no problem in that front. I am saying please implement in a systematic manner. I will register it. It's not that I can't register. I'll have to register at some point of time. It's a track and trace. It's a system which is perhaps going to be good in the future. But while doing this, you can't take away my profit. The statement earlier made was that even the central bond people are also contributing to it. No, the 6% that was introduced was in terms of a previous order that was passed, not under this scheme. It is only me who's penalized. That is my case. And that is what I've been saying from day one. You cannot do it singling me out. That is all my grievances. If it is connected to the implementation of a scheme, obviously it will be challenged. Enhancing is the scope, is bringing into the fact that this implementation is wrong. By which you're taking it.
It can't be such a fantastic coincidence.
I don't know. No, but
the scheme is introduced and your profits being reduced.
This is what has been done at the same time.
No, I mean, the only thing is the link. You see, that's the thing. We understand.
But the statement is extremely important. It has gone live on 1st of October. If it has gone live on 1st of October, my lord, how? How is it gone live? Because my rejoinder specifically stated that no, it's not being notified. It's still on a trial and error basis. Then you can't extract the money from me. There's no hardware.
Who is extracting?
I am only saying.
I'm not extracting money.
No, listen.
I am only saying.
We understand.
You have already reduced it.
They are already reducing your profits.
Yes.
Right. But then that's by way of another amendment to the rule.
Yes.
Right? And while on the other hand, the scheme is by another amendment, which that is different. So they are parallel.
Yes.
But what you have to satisfy the court is that these two parallel actions of the state, whatever, in reducing your revenue and in filling the scheme, are correlated. In such a
are
manner,
all interrelated.
They cross somewhere.
Or
and then
interrelated.
Like,
Exactly.
But then you have to keep in mind that trade in liquor is not a fundamental right.
I agree, but I get the and I said on the last occasion, my lord, the moment I run a license given by the government, I get the protection of under 14 as well as 19. That is what the law says. So I am actually running, the license is given by them. It's not an independent license. I run under your shelter. So the protection under restriction comes into picture. Yes. I have a judgment to show to that effect, and I show it to lordships that I get the protection. So you cannot just dismiss me by saying that it's a purely a state. Yes, you have a right to impose, you can impose.
No, we understand.
So therefore it's all correlated.
It's only where they cross. And if you can satisfy the court that they cross
in
such a way that
I will, my lord.
Interference,
I will, my lord, that you cannot have done this by only using my source or profit.
Are your pleadings complete?
It's all complete, my lord. He's already filed. I've already filed a rejoinder.
If I have understood now their case, my lord. Their case is that reduction of margin has got something to do with this scheme. That is what it is not there in the pleading. I don't see in the reputation.
It is not my case, and I repeat once again, my lord, it is not my case.
So I have not. So
I have not
now my
challenged the
friend is
competence.
saying that reduction of margin will have something to do with this scheme. Reduction of margin is an independent exercise which has been carried for central bonded warehouse, for the bonded warehouse, for others also, my lord. This is the entire independent exercise. This is an independent exercise.
But then you can't also ignore.
So if your lordship
the coincidence, you see, 13th of August and 12th September.
No, my lord.
Within 1 month, you devise a system whereby you increase your revenue.
No, it is a long drawn process.
Increase the profit.
It is a long drawn process.
Anyway, I think we'll hear you.
Lordship will have to hear us on the main core issue.
My only grievance still remains, my lord, is that the new prices have come into effect, and let him say that I am not selling that product. I am selling that product at a price which I have already said.
You have to sell the product.
I cannot scan the product because the hardware is still not.
Now they're saying that MRP is as per the old system. As per the other amendment whereby the reduce is not related. That is a stand. We can't interfere with that right now. It deserves a thorough hearing. We were on the impression that we could at least on interim matter whether we were under impression that it's correlated and linked in such a way that that is impinged upon.
In fact, everything arises from that.
Yes. Anyway,
everything arises from that, my lord. So may I only say this, my lord, that in today's the new cost price which has already come, which is approved by the department. I am running the scheme already. I have to register. There's no other way out. I will register perhaps in course of time. But
so one thing, if your providers have not provided that 240 and 150, then why?
No, my lord. The problem is that they come. They know.
Now, one thing, Mr. Afghan, this is
maybe not on law.
Just
not on
question.
Not on law.
Now, if you put in the new rate,
yes, my lord.
Right, then and you say that 240 and 150 still to be what you call implemented.
They are implementing. That's what I'm saying, my lord.
That's what.
No, if I have understood,
anyway,
we will examine.
My protection, my lord, I was saying
the entire will go haywire. Everything is now.
Nothing is in place, my lord. Anyway,
everything is in place.
Nothing has gone live. He's not been able to. They have not even gone live, my lord.
They want to strike down my rules.
No, absolutely not.
And now we see today we will not be.
Your lordship will hear the matter finally, my lord.
Hear the matter finally.
Hear the matter finally. I'll be grateful, my lord.
But you please come prepared. At least because you see, you have to assist the court.
I will.
Yeah,
but as long as your lordships are clear on this fact that they are interrelated. No. My lordship's only request is your lordship always has to remember that this is all interrelated. That is my part to show your lordships that yes, it arises against them.
But General said that there are no pleadings whatsoever.
I will in fact show you. In fact, my entire writ petition stands on that ground to say that this is not correct.
Yes. Very interesting. Yes.
What date you have?
When? At least
4th December.
Yes.
Hearing. Item number 4.
Manor, I just requested.
Yes,
I will extremely grateful, man.
This is the matter for consideration also.
May it please your lordship.
Yes, Mr. Goyal.
My lord, the writ petition has been filed, my lord, challenging the item number 4, my lord.
Yes.
May I start, your lordship?
Yes. WC 439.
My lord. Now notice the proceeding initiated, my lord, under section 148 capital A.
Yes.
And 148 despite the fact that the proceeding under section 153 capital A that I will place, my lord, has not been carried out
Yes.
after the search operation being undertaken by the revenue authority, and subsequently, your lordship, the jewelry which was, my lord, seized were released by the revenue after due satisfaction, and after observing that there is no income escape assessment, and there is no liability, my lord. So, my lord, before coming to, my lord, annexures and all, I would like to place, my lord, facts of the case in nutshell, your lordship. My lord, on 16/70/2017, your lordship, a search operation was carried out in Delhi, and my bank locker was, my lord, sealed. Subsequently, I was told to present for operation of that locker, your lordship. And accordingly, my lord, on 3rd January 2018, locker was operated in presence of revenue authorities, my lord. And in that locker, jewelry, which was my Stridhan, your lordship, it was found, as per the revenue, it was found to be valued at, my lord, rupees 61 lakhs and odd. Out of 61 lakhs and odd, my lord, 48 lakhs jewelry was seized by revenue authorities. Thereafter, my lord, I have given my affidavit. Along with affidavit, I have annexed, my lord, my return filed, wealth tax return as well as income tax return, where I have disclosed the entire jewelry which was seized by revenue authority. Thereafter, my revenue authority in the year 2024, my lord, released my jewelry after observing that there is no assessment pending, there is no liability, and after, my lord, release, and at that time, my lord, during that period, my lord, no proceeding under section 153 capital A was undertaken, which is the, my lord, mandatory in case of, my lord, incriminating material is found during search. My lord, it was released, my lord. After release of my jewelry, my lord, in the month of September, revenue has issued notice under section 148A asking me why not proceeding under section 148 be issued. Notice, why not notice under section 148A issue. We filed our reply giving detail, but, my lord, in the order passed under section 148, my lord, our reply was never considered. The revenue has not taken into consideration that no proceeding under section 153A was taken, which is mandatory in case of search. That was challenged, my lord. This is the present proceeding. This honorable court was pleased to stay the proceeding. My lord, kindly come to Annexure 1, page 79, my lord. My lord, this is the letter dated 2/1/2018, my lord. It was addressed to, my lord, Deputy Director Income Tax Investigation. Here, your lordship will see I have given an affidavit, my lord, serial number 1, an affidavit affirming locker number so and so belongs to me, and that the all articles kept in it belongs to me and my family. That the aforementioned locker has never been held as Benami, and it solely belongs to me. Copy of my PAN card, copy of income tax return acknowledgement for assessment years 2016-17, and wealth tax return for assessment years 15-16. So I have given, my lord, all the details that it is not unaccounted for. In fact, in my wealth tax return as well as income tax return, I have disclosed this, my lord. And thereafter, my lord, after submission of that, my lord, page 95, revenue locker was operated in presence of revenue, and revenue has prepared Panchanama. Along with Panchanama, my lord, page 97, my statement under section 132 subsection 4 was recorded, page 97, my lord, typed copy. Here also I own my that locker belongs to me, and all the jewelry was duly accounted for. And on And thereafter, my lord, page 108. This is very important, your lordship. Annexure 3.
Yes.
My lord. It was issued on 4/3/2024. Right hand side.
Release of the assets.
My lord. Here the observation of my lord revenue, my lord.
Yes.
May I read, your lordship?
Yes.
At the top it is written administrative approval for release of seized assets in the case of so and so. Petitioners before your lordship.
Yes.
The DCIT Circle Shillong by letter dated 28/2/2024 and 1/3/2024 has submitted a proposal for release of seized jewellery, which are duly forwarded and recommended by Joint CIT Range Shillong by letter dated so and so, wherein jurisdictional assessing officer Shillong had recommended, this is very important, for release of seized jewellery item amounting to rupees 43 lakhs and odd, maintained in the name of Srimati Suchita Agrawal, petitioner before your lordship, so and so. In this connection, SSC has requested for release of jewelry items seized during search and seizure operation on 3/1/2018. In the report of assessing officer, which was duly forwarded and recommended by the range head as a search and seizure operations under section 132 IT Act 1961 was conducted by Investigation Directorate 1 New Delhi in case of Srimati Suchita Agrawal at the locker number so and so maintained at so and so South Extension address. During the search, jewellery of rupees 61,14,858 were found, out of which jewellery worth of rupees 43,65,200 were seized and deposited in a strong room in Delhi under the custody of additional director so and so so and so. In this case, my lord, thereafter, my lord, in this case,
no proceeding.
No proceeding under section 153A or 53 were initiated. Srimati Suchita Agrawal and Sri Manish Agrawal have executed affidavits before the Notary Public Kamrup at so and so, stating that the locker number so and so was jointly opened by them, and whatever content in the said locker belongs to Srimati Suchita Agrawal, wife of so and so. Thereafter, my lord, assessing as reported by assessing officer and range head that no proceedings of assessment, penalty or interest is pending and no existing liability is outstanding in respect of the SSC Srimati so and so, Panama so and so, the gift tax so and so. In view of the above, administrative approval is hereby accorded for release of seized jewellery items in the case of so and so so and so. So my submission before your lordship, the revenue, when came to know that there is no incriminating material, the income has not escaped assessment, has released jewellery, your lordship.
Yeah, this is 4/3/24.
My lord, 53, 150.
No, this date of his order.
Date of order is 4/3/2024.
Okay. Yes.
So, and no proceeding, which is mandatory in case, my lord, unaccounted assets are found, my lord, in Income Tax Act. Legislature,
so they have come and served notice on you seeing the escape assessment.
My lord, on the same material,
on the same jewelry.
Same
After
jewelry.
seeing that is already it's
no new material, my lord, no new evidence. After closing,
basically your case.
My lord, this is my case. I have judgments also.
Assessment year of so and so.
18, 19.
Yes, that this.
Same adjustment years. Everything is same. Change of opinion cannot be the ground of my lord reopening, my lord.
Okay, carry on.
My lord. Thereafter, my lord, page 110. This is the impugned notice.
Annexure.
Annexure 4, my lord. Okay. It's a judgment.
1 second.
Here, your lordship will.
Yes. Mr. Chetia, how long will you take?
Lordship, not much time.
15 minutes from my side, 1-5. 15 minutes now, my lord. Because your lordship has understood, I no need to, my lord, place more judgment and all. Only 3 judgments I will place. It will squarely cover my case, my lord.
Fix it. Let's fix another date. Otherwise,
See, Mr. Goel, there's a small, it's not a problem with you or with the matter. There's not a problem, administrative problem with today's roster.
My lord.
If you see supplementary list, this roster of the person,
My lord.
that's the only thing that we're supposed to take only income tax appeals.
Okay.
So that might be, otherwise your case very simple.
Very simple, my lord. Lord, my lord, but some of the matters.
We'll post it another date. At least, we have understood the matter.
Lordship.
Yes, we'll just take a date and then.
My lord.
Yes, whatever.
As your lordship.
Yes.
Let it be on 4th, Lordship. 4th of December.
It's the matter of further hearing on 4th.
Deeply, Lordship.
Yes.
My lord, regarding that roster, my lord, it is clarified on that. If something is wrong
Yes,
in
no,
that.
that is why we're posting another date.
My lord. Earlier also it was listed before your lordship only, my lord.
No, yes, that's the thing. And so I think there's some, like if you see today,
my lord,
in the supplementary list, the court master can show you.
My lord.
You see, whereas realized it.
My lord.
You just see in the roster, you can see.
My lord. In the next date, if it is listed before your lordship, then my lord.
No, that will be corrected by that time. Only that there was some lot. See that these are procedural things which
deeply obliged, my lord.
Yes.
I'm obliged.
Daily list item number 2.
Number 2 is a Yatra matter, Your Lordship. We are awaiting report on the respondent number 10 who's been impleaded recently.
No, whose report, who's appeal number 10? Anyone? Any
Save of
appeal?
Mouse and Ram.
Because we have to deal with this matter first.
Yes.
Whether they can be mediated or not, then we'll pass orders. If not agreeable for mediation, then we have no choice.
May I please, Your Lordship, on the last occasion, it was on our part to see the status of the report.
Yes.
But what we have got the finding is that the service report has been served by the registry itself, so we cannot get any reports.
Okay. Yes. We will fix it after 2 weeks. Yes.
Response 6, 7, and 8.
Yes. It's submitted that the registry itself was to obtain the status report. On inquiry, it's been reported from the registry that the service report is not yet received. This is matter after 2 weeks for further orders.
Oblige, Your Lordship.
Yes.
Item number 4.
Supplementary that, but should be orders done.
Yes, sir.
Supplementary orders done.
That mediation.
Should be does just return from the mediation.
Who?
The matter.
Oh.
The mediation has failed because the parties were not willing to settle.
Is the proceedings have complete?
No, Your Lordship.
Yes, sir, it is reported. After noting. Yes.
Then do you have to appear. Here, even respondent number 10 is yet to appear, my lord.
They appeared in the thing in the mediation.
Yes, they did appear.
Then,
but so far as in this present proceedings concerned, they have not appeared.
Who's this? 10 is Yalong village.
No,
10 is the Daloy. Yalong is the petitioner, my lord.
Oh, petitioner Yalong, why Yalong?
9 is the Persi village which I am representing. 1 to 8 is the district council.
Put for orders.
Yes.
Yes, as reported that the mediation proceedings has not been successful. This is matter for orders after 1 week. Orders, then we will pass whatever orders necessary for service.
Item number 5.
Wait, please, Lordship. Lordship, we've received the affidavit by respondent 3 to 10. I'm bringing time to.
Yes.
We've received the affidavit, Lordship. For respondent 3 to 10, Lordship. I'm bringing some
3 to
time.
10 is
the complainants. Lordship.
Complainants. 11 to 13 you filed.
We have filed. No.
1 and 2.
1 and 2
1 and 2
is
I
filed.
filed. Oh, sorry, 1 and 2. 11, 13 not filing.
I'm praying for
Yes,
some time to
Ms.
find
SDEP submits, he just received the affidavit filed by respondents 3 to 10.
3 to 10.
He prays for allowed how much time?
2 weeks to file a rejoinder.
2 weeks to file rejoinder.
Obliged.
6.
Lordship, in item 6 also, Lordship.
Same order can be read of second.
You filed it?
I have not filed in this, but I'm thinking relying on this affidavit, Your Lordship, because the issue is the same only.
No, in 6, relying on affidavit file in item 5.
Very well.
Mr. Edhar submits that the affidavit file in WPC number
298.
298 is item 5 will suffice to answer the questions. Will suffice.
Only, Lordship, the parties are different. I don't know how some other party will rely on it.
Their detriment.
Very well.
Yes, will suffice to for respondent 3 to 9 from the application. 1 and 2 is filed.
Yeah, Lordship.
Yes. You want to file a rejoinder or not?
I'll file a common
together
rejoinder. Obliged.
7.
My lord, we have served the copy of our rejoinder. However, we could not file it, my lord, because there was some defect. We have served them the copy.
Final opportunity was given. When was this served to you? This
Day
morning?
before your lordship, on the 11th.
11th, my lord. It was before this,
1
but
week for the time. It is supported. It is submitted by Ms. Little Petitioner that a copy, advance copy, has already been served to the respondents. However, the same would be filed due to
My lord, there was some defect with the notarization.
Some defect in notarization. Yes. Petitioner is allowed further 2 weeks time to file the same.
8.
Yes.
Obliged,
Obliged, my lord.
Lordship, this is an application for continuation of delay, Lordship. There's a
Okay,
delay
appealing.
of 26 days, Lordship. in
No,
preparing
he's
the
appearing. Yeah, objection.
Lordship,
No, Your Honor. Your Honor, let the matter come on next week.
Who's your leading counsel? Who's leading you in the matter?
Mr. Asarindo.
Okay, yes. The entering appearance today only.
Yes, Your Lordship.
Your name?
T. Islam.
With the Islam. That's an appearance in behalf of both the respondents.
Yes, yes,
Such notice is complete stop. Let this matter come up on 9 on his prayer. Or let the matter come up to 1 week or when?
Any day.
9.
What happened? Settle, unsettle?
Not settled, my lord. It was tried by both the sides, but ultimately could not.
Complete here?
Yeah.
Yes, this is as reported that mediation proceedings were successful. This is matter for hearing after 2 weeks.
10.
Please, Lordship, this matter can be posted for hearing. The pleading is complete. I have filed my rejoinder.
Yes. As the parties submit that the pleadings are complete, this matter for hearing and so and so.
11.
Yes, Lordship.
11.
please, Your Lordship. Lordship, in this matter, I'm seeking accommodation, Your Lordship. Then it's near us out of station.
Asking for. Why are you seeking accommodation?
Lordship, it's near us out of station. No, Your Lordship. Lordship, if this matter can come up on Monday, Your Lordship.
You've seen the last order was recorded.
Lordship.
You've seen what's written in the last order. You read out the last order. What does it say?
They have got so much opportunity now.
Only waiting for instructions. Then?
Lordship, let it come on Monday, Lordship.
Last time you said that instructions have been received, but the senior he's not telling you what the instructions are, correct?
Lordship, he's not in town, Lordship.
Okay. On the Prince escrim, this matter to 1 week.
12.
My lord, pertaining to this matter, there's some urgency now, my lord. After the order dated 16/9/25, my lord have directed the respondent to stop further destruction to my property, my lord. So what happened after that, my lord? There was a meeting held by the Dorbar Shnong on the 11 November 25, or last Tuesday, my lord. In that meeting, my lord, they have taken a stand that the plot number 10, which was claimed to be our land, that they never issued the Dulir Pata to us, my lord, till date. That plot of land is taken a stand that it would be given to someone else. It's the place where we have been residing, my lord.
Who's 3?
3 is the same, my lord.
3 and 4 same?
3 is the same, my lord.
Who's appearing for this ex-secretary of Dorbar County Pastor? You're appearing?
No, Lordship, I'm for 2.
My lord, I'm
No,
for the
you're
wrong-
appearing.
I'm for the wrong Bashnong, my lord.
Nambashnam?
My lord. Sardar and wrong Bashnong, my lord.
Number 3 is Imam Makarim. Number 4, Dorbash Headman. Yes. Have you filed affidavit?
Yes, we have.
What does it say in the affidavit, number 4?
My lord, they stated that just only 3 plots of the land which were given to us. But
It's
that
like a
is,
civil dispute. That means
Yes, my lord. It is a title suit.
my lord, but the problem in hand is that all our plantation, everything has been disrupted, my lord. The ginger plantation, our broom plantation, everything, my lord.
even if uprooted your plantation.
Yes, my lord. Everything has been
Is that
destroyed.
correct?
That's not correct, my lord. There's an order. There's also an.
My lord, we have several representation to the BDO, to the DC as well, my lord.
Recently?
Yes, my lord.
No, man, that is during the year.
No. I mean, you're saying what's happening now.
Right now, my
urgency
lord.
is there. You're saying because they are causing destruction to your property.
No, my lord.
Right of the order saying that no construction of the road.
Yes, the construction of the road they has stopped, my lord.
Then?
But the front part is where we are
those
residing,
things
my
are
lord.
have not been adjudicated by the court. So, are you doing any other activities?
No, my
there?
lord. We are not doing anything.
That is the information I received, my lord.
Information received, we have to put it on affidavit. We can't just take your submissions.
Yes,
My lord, since the matter is pending here, we will not take any.
No, we understand.
We will not
that.
do any activities.
But no, he's made submission that yes, Mr. So submits that the respondents number 4,
my lord,
is still engaging in activities which is causing destruction in the petitioner's land stuff. The same is refuted by MS so and so appearing for respondent number
4.
Number 4, who submits that after the orders of this court dated 16/9/2025, no such activities are being carried out by the respondent number 4 stuff. Next, by be that as it may, if the petitioner still has some grievances, he may put the same on affidavit for consideration just after 1 week.
Obliged,
You put an affidavit.
Yes, ma'am.
But otherwise, it's a civil dispute, then you can't do anything.
13.
Obliged.
13.
Yes. Yes.
Lordship, I'm appearing for respondent 3 and 4. I have already filed my affidavit in opposition on Monday.
Yes.
Lordship, we seek some time to file a reply, Lordship. They filed the affidavit last week, Lordship.
Okay,
At least
Mr.
4 weeks may be given you, Lordship, to file a reply.
No, 2 weeks enough. Mr. Saikia, please phones allowed 2 weeks time to file counter to FS5 response number 3 and 4.
Yes, Lordship.
Yes,
Lordship, interim order.
Yes, after 2 weeks, interim order, if any, shall continue the next day.
14.
Please, Lordship, we have sent the affidavit for vetting and signatures.
Lordship, this is regarding the pending salary, Lordship. Now the GHTC, they have received the amount and other they are
received
getting
the
the
amount?
Yes.
Lordship, we have sent it for after
12 months salary also they have received, and now the government then they are,
You have been
despite
paid
of
12
I have
months
not been paid. I have not been paid till now, Lordship. I have not been paid. The petitioner here in
Has the
not
money
been paid.
reached this council?
Is
Lordship, we
rich,
have
Lordship.
got some communication. We have sent the affidavit also for.
Affidavit is-
verification.
One sec, is that money has been received, that bailout package
I am
that
not
the
aware, Lordship. Of
No, Lordship, I am stating they have received because I have a lot of friends. I mean that employee. I have been appearing many other cases also. They have categorically make a mention. They are already receiving the salary. 12 months salary already got it, and from the month of November, which the government have promised, that also they have received. There's nothing remain. And in this petition, this is the 34 months. This is they are not disputing. This is the amount.
No question dispute.
Yes.
Whether-
So they have received, my lord. They have received.
What instructions have you got?
Lordship, we have received
see.
instruction that it will take some time to process it, Lordship. So I just are praying for.
He said his friends have all got.
Lordship,
Yes, they are good. They have even make a in the media statement, the newspaper also it comes out. All the employee of JHDC, they have received 12 months salary, and also the plus the month of November also they have cleared. Yesterday in the press release they have make a statement. The president of the
November is not over, already cleared of salary.
for that 1st November. That money already got it. For the month of October, they have already
his
received.
case is not of pending salary, Lord. He has resigned. He wants the arrears. So those
No,
are yet to be processed.
not at all. Just see my Annex 10. Is making a post statement.
You're looking for arrears salary?
No, not at all. Only
salary.
See only the salary.
Backlog of salary.
Not backlog salary.
You
just
resign.
resign, but
anymore.
but my due.
If I may, Lordship will see his own annexure at page 9.
Yes.
In the last line, Lordship, he has resigned from the service of the GCC on 13 January 25. And in the next page, this is the sanction order.
10.
It refers to backlog of 34 months of salary. So this is, Lordship, not that 12 month of.
Why you resign?
Because I resigned because
not getting salary.
Not getting salary. So I was doing business. So that is my due, my lord. Because I'm not claiming for any.
Lordship.
Yes, Lordship.
As paid for the 1 week expense of affidavit. Yeah, the cases are different footing. You're not a serving employee.
This is not under that package, Lordship.
It's only for serving employees that package has been given.
It's included also.
Bad luck.
Salary.
15.
Obliged, Lordship.
But plus, Lordship.
Lordship, in item 15, I appear for respondent number 8. Lordship, I'm praying for 2 weeks to file an affidavit.
We have a similar prayer, Lordship.
What's the matter about?
Service matter, Your Lordship.
Teacher, my lord, related to teacher.
The fresh matter?
Yes, my
Not
lord.
really.
This is the
Not
second,
really.
second,
second round of
respondents pay for the 2 weeks time to file affidavits. Just that after.
16.
Obliged.
May it please Your Lordship?
Yes.
I am praying for respondent number 567. I pray for some more time to file an affidavit in opposition.
You have corrected the cause title?
Yes, Your Lordship.
You will correct it, Mr. Khan?
We haven't received the corrected copy.
No, the cause title, they've corrected the cause title. Let me see. The correct nomenclature is VIMC.
Which implementation?
Plus implementing and monitoring committee.
Pursuant to the order dated 24/10/2025, the correct nomenclature of respondent number 8 has been given, has been inserted in the cause title. If they already taken steps on them.
Yes, Your Lordship.
You've taken step number 8. Yes. Mr. T.S. Tam submits that steps have also been taken for service of notice on behalf of. You're paying for 8 also?
567.
For on respondent number 8.
For
Mr. Khan, you're filing your affidavit.
1 week's time, Lordship.
What's your name?
D. Benwan.
You just MS so and so. First, Mr. E.R. Khan for 124 and M so and so for absent pay for allowed for the 2 weeks time for affidavits. This after 2 weeks for service report. Oh, they already served 8.
I already
on 8 and for affidavits by the other respondents.
17.
Please, Lordship. Lordship, we have received an affidavit filed by the state. I am praying
We've
for
given
some
an
time.
advance copy only, Your Lordship. We had to, because it's not yet been signed.
Right.
Yes, the advance copy has been served on the petitioner, the affidavits. The letter, the AG submits affidavit to be filed. So she pays for 1 week's time
1 week's time
to complete the same.
Lordship.
18.
Yes.
Mr. Lordship, I have received the copy of the affidavit of opposition filed by the government, and it is very surprising to see the affidavit filed by the government. The director was asked to take a decision in accordance with the law by the Supreme Court. In fact, he has taken a decision, and the decision taken by the directors in the affidavit page 20.
Mr. General, you file affidavit.
Oh, we haven't filed an affidavit, my lord. Actually, the matter is infructuous, my lord.
Okay, no, let's see. What does it say?
The matter cannot be infructuous because the order impugned herein is the order passed.
Let's see. Where's the affidavit filed by the government?
The 28, page 28, the affidavit is annexures 7.
Yes.
Annexure 7 says, in compliance to the Honorable High Court judgment and order dated 5/3/2025, passed in WPC number 5 of 2024, the Managing Committee of Rai Bahadur Hindi Secondary School, Kitty Shillong, represented by the President and State of Meghalaya, I am to state that the proposal for reconstitution Managing Committee of RBA Hindi Secondary School for a period of effect from the issue of this order till 3/2/2027 in reference to the letter number so and so 20th November 2023 forwarded by the District School Education's office is hereby approved with the following members here. This is the.
Yes. So why is funny about this one?
Now, further, in the best interest of the school, in accordance with Rule 2E of Section 11 of the Assam Education Department Revised Rule 1955, an additional 2 members in excess of the members prescribed above are proposed to be nominated for the inclusion in the managing committee of the school. Specifically for the above mentioned period, this nomination shall not include. Intended is to set precedent for the future appointments, and 2 additional members who are.
What objection you have to debate them included?
In this is the order pass.
Now you are the president.
I am the president.
Then
I am the president. This is the order pass. Of course, after there was a hearing. After the hearing, this order was not communicated to me because this is the internal communications. So this is the order passed in pursuance to the judgment and order passed by the Honorable Court, saying that these 2 members who are contesting this may be co-opted in this committee, and this is the order passed, and district education office, district school education officer is directed to constitute a committee. Now after this, I have not received any copy because there was a hearing as per the affidavit. I did not receive any copy, but subsequently when I filed a contempt of court before some court, they produced the impugned order that this committee is constituted with the members of the Marwari Panchayat. So that is the order I have challenged. This order is passed without any speaking order, without taking a decision.
Now this order is dated when?
This order is. This order is dated 26 May 2025.
This order.
As per page 27. The order is not dated anything. They have not given any date here. But as per the forwarding letter, it appears that 27. Now, when the contempt of petition is filed, in my writ petition, Lordship may see the annexure 11. Page 212. This is the order passed. We have challenged how this order has been passed, constituting a committee of the proposed by the Marwari Panchayat. He said to the Deputy Secretary to the Government of Meghalaya, constitutes a managing committee in compliance of the High Court, Honorable High Court judgment order so. So this is the order passed without any speaking order, without any reasons. How this order, earlier the director has taken the orders in favor of the managing committee, in favor of the petitioners, and subsequently this has changed.
No. This is 13 August.
This is 11 August.
See, MS Jhangi, this is something very strange. You see this order 27th?
Order is?
This order dated 27th March, correct?
March,
27th, 26th May.
May.
13 August. Now, how do you reconcile between this and that?
Which one?
There's these 2.
Between this page 28, 27 and in 2012. What have you explanation have you given?
Your Lordship, in page 28, this was in a draft constitution, Your Lordship. Then thereafter, Your Lordship, at page 31, annexure 10, Your Lordship, the government has taken a decision that the Marwari Panchayat would be constituting their managing committee.
Then how is the matter infructuous?
Not infructuous.
I'll explain. I'll take a minute.
Now where does order come from, this 27? How would be a draft? Then where are the proceedings?
Your Lordship, this is what we have received instructions. This has gone, after we had given this order, Your Lordship, of 26th May, then a letter was received by the Directorate of Education asking for, the next page, Your Lordship, at page 29, annexure 8, in inviting a reference to the letter on the subject cited above, we have given the reference of 26th May 2025. I am directed to inform you that the draft order is not in the speaking order format and request you to kindly furnish all relevant documents related to the reconstitution of the managing committee in respect of Rai Bahadur so-and-so for further necessary action from this end. So, Your Lordship, the Directorate were asked to submit all the papers. Thereafter, when all the papers were submitted, Your Lordship, then Annexure 10 came into existence.
Lordship, the order was directed to the district education officers to take a decisions and to pass a speaking order strictly in accordance with the law. Where is the order of speaking order? Where is the order passed in accordance with the law? This is the order passed by the directors on 27th.
Director will call for personal appearance.
My Lord, if I can take a minute, my Lord. If I can take a minute.
Sorry, Mr. General. Yes, we can't have this kind of
my Lord,
hide and seek game.
My Lord, the clarity is in the documents itself. If I can take a minute, my Lord, page 16, if Lordship kindly looks.
See, one thing is that strikes the mind of the court first, then we will hear you. The thing is that now, if one order is passed on 27, some draft, something else.
Yes, ma'am.
What proceedings are there? You not annex any proceedings. Then where's the hearing? The directed for hearing, correct?
Yes, ma'am. Yes. So hearing was conducted, my Lord. That is at page 22.
Page 22, Your Lordship. The hearing is there, Your Lordship.
The entire proceedings are there, my Lord. Page 22.
Annexure 5, page 22.
Who presided over this?
This was Director of School Education.
I personally appeared.
You appear personally?
Yes, I appeared.
You say that these minutes are correct?
Yes, this minute is correct. But the decision taken is here on 27, Annexure 7. But afterward they changed. They said, no, this is not the committee to be constituted. Committee proposed by the Malwari Panchayat to be constituted.
This decision was taken by the Director of School Education and later on Deputy Secretary of Government of Meghalaya.
My Lord, my Lord, what is important is for Honorable Court to appreciate that this was a draft order. It wasn't a final order. It was sent for approval to the competent authority. Competent authority, my Lord, page 29 has sent it back, my Lord.
With all the documents.
Asking for all the documents, my Lord. If Lordship kindly looks at page
according to proceedings, where's the submissions made by you?
Yes, where's my submissions?
Where's it recorded here in the proceedings? Because you're supposed to hear you also.
Yes, my Lord. Yes.
Where's that?
My Lord, there was another meeting conducted, my Lord.
How is that possible?
Because what has happened is the first draft order was not.
Forget about draft order. Now you're saying this is the minutes of proceeding.
Yes,
now where's the side of Mr. General's client? Where are the submissions recorded?
Para 3, my Lord.
Para 3, Your Lord.
Para 3. What is the order?
Para 3 at page 22, my Lord.
That's all.
This one. Now see, in earlier case, which I have enclosed here, page 213, in case of Maharashtra, both the parties were heard and the very elaborate and speaking order was passed by the director. It is a page 213 in my writ petitions.
No, that is what. Why are they conflicting orders and conflicting
orders?
Looks like a proceeding. So this order is compliance order 13.5. So and so. No, this is a different case.
It's from a different case.
This is the Lordship. I have explained. This is the way to pass the order after hearing both the parties.
What now? See is the records as how did the orders arrive. It's only clarifying. See, Mr. Qureshi, please listen. The thing is that this court arrived at a finding that the process has been adopted as well. Orders are passed by this court, whether it is a fair hearing, whether given adequate opportunity, and whether this.
No, but this order, Lordship, the order of Annexure 7, this is the order in my favor by the director, passed by the director.
My Lord, there is no allegation in the writ petition that he was not heard, that he was not given a fair opportunity.
Order passed in my favor.
What's happened is that a draft usually.
So the draft was sent for approval.
Draft usually will indicate, because a draft has been arrived at in May, correct?
Yes, sir.
That was the first draft, my Lord. That was the first draft which was rejected, my Lord.
It was arrived at after your. This is like a purported hearing you had on 29 April, correct?
My Lord.
You see the draft arrived at after this meeting, correct?
My Lord.
Then, is there any other proceeding that you didn't agree the draft another meeting was held?
No.
Where you said they had to be changed.
Yes.
My Lord, what has happened is, if Lordship kindly sees page 29. Page 29.
Page
29.
Try to understand.
Yes, my Lord.
what this court is saying is this.
Yes, madam. Yes, madam.
There's one order.
Yes,
at
madam.
Annexure 7. Correct.
Yes,
that's supposed to be till May. Correct.
My lord.
Now there's supposed to be a culmination that's come out from this proceeding of April.
Correct.
Okay.
My lord.
Now that letter was sent, and then another order is issued in August or sometime, which is a total diametrically opposite to what has been. Now, where are the proceedings that you had to change the order totally from that?
My lord, if I can point out, my lord, page 29 first.
Yes, where is that?
Page 29 first. This draft order of May was sent to Deputy Secretary to the Government of Meghalaya, who sent it back, if I can read, my lord, in inviting a reference to so-and-so.
So where's the proceeding again after that?
My lord, there was no subsequent proceeding.
No, the draft is there that came out from the proceeding of April.
My lord, if I can,
Column, yes.
My lord, if I can elaborate.
Filed by the state respondents, wherein certain doubts have crept in with regard to how the proceedings were conducted. You filed a rejoinder also. Petitioners permitted to file a rejoinder. Should we call him personally?
Not at the moment.
Otherwise, we will take him to task.
Not at the moment. Let them
If the records are not straight,
My lord, why?
whatever it is.
My lord, why I had said that the matter was infructuous? Why I had said the matter was infructuous? If lordship looks at the last document, that is at page 34.
Yes, you filed a rejoinder. By within 1 week, yes. We'll see. After 1 week, yes, we'll for the order to follow. We are not satisfied. If the government can show that yes, there was a relook at the entire thing, they were called again, there was a rehearing, and the second draft was arrived at, and yes, but nothing is there. Yes.
19.
My lord, we have just received the correct address for respondent 15.
Yes.
Kindly pray for 2 weeks' time, my lord, to take steps.
Even 4, 5, 7 to 10, 12, and 14, and 16, and 17 not received. You obtained status?
Yeah, we have received, my lord. Only
You obtained
15.
status?
Yes, we have.
On all the
Yes,
others?
they all delivered, my lord. Only 15. Respondent 15 is left.
The council petitions prays without to take fresh step submits that he has obtained the correct address of respondent 15. Prays allowed to take steps within 3 days. Prays allowed, yes. He further submits that status on the other respondents, that is 4 to 5, 7 to 10, and 12 to 14 and 16 have been 12 to 14, 16, 17 have been received. He prays without to file and after getting service. Prays allowed, yes, just after 2 weeks. Yeah.
20.
Please, Lordship. Lordship, I pray for some more time, Lordship, to find my counter.
On account of?
Lordship is almost done. Just require some more time to finalize.
2 weeks that's allowed, yes.
21.
I oblige.
Yes.
Respondents are yet to file their affidavit, Your Lordship.
Lordship,
Yes.
from respondent 5 and 6, I'm receiving time.
5 and 6 is? Yes.
Seeing time of 3 weeks, if it pleases Your Honor, or Your Lordship.
What about number? She's running homestay.
Yes, Your Lordship. Your Lordship, the water connection is yet to be restored, Your Lordship.
The electrical connection.
The water connection, Your Lordship.
Water connection.
Yes, Your Lordship.
You've disconnected the water.
Lordship will be replying to that in
No. Who supplies the water? Water and light is an essential requirement for every household.
I have no instruction relating to that, Your Lordship.
Have the police interacted with the
Lordship,
5 and 6?
actually we're quite busy. There was a funeral in Sora, so
No,
Lordship,
don't. This is order dated 2310.
my lord, yes,
Then?
but Lordship, within the next few days, my lord. Of course, we have filed a preliminary report.
Yes. Yes, what is your name?
J. Thaba. J. Thaba.
Mr. J. Thaba attended appearance on behalf of the respondents. Oh, you already entered appearance. Who's Mr. M. Marwin?
When he entered appearance last
He's your colleague. Yes, so 4, 5, and 6. Praise for the allowed further 2 weeks time to file affidavit. It's a counsel not filing. Yes, MS NG Shilala, senior account advocate, also prays for to obtain specific instructions pursuant to Order 2310/2025. Not stop, Neklara. It is submitted by the council petitioner that the water connections yet to be restored.
Lordship, I pray the interim order may be continued.
Just after so and so, just after 2 weeks. In the interim order will continue.
I'll leave that, Lordship.
22.
Lordship, I have taken a step to issue notice to private respondent number 5 and 6, 4 and 6. The government also yet to fight the affidavit.
This is the second time come after motion.
Yes, Lordship.
First one indicates service report not complete. Service not complete on 4 and 6. And how much time?
2 weeks time, Lord.
Yes, MS so and so on behalf of the one pays for 2 weeks time. Just after 2 weeks for affidavit and for service report. Yes.
23.
Yes.
My lord, I'm entering appearance for respondent number 2 and 3 here for the first time. MECCL.
Yes,
I'll need 2 weeks, my lord.
OI Bank and the appearance behalf on 2 and 3. So you notice complete or respondents just after 2 weeks for instructions to affidavit.
Supplementary. Item number 3.
Pak nak akut bapak juga. Yang gitu-gitu, ha? Ini this hearing matters, I don't think we'll take up hearing matters today. In the hearing list, we'll take up this matter now. How much we can cover, we'll see. No, we take a lead matter 438.
Yes, sir.
Dr. Mozika. Yes. They have become a blockbuster. Yes.
This is our judgment.
Where's the compilation? We've gone through the.
Yesterday, I referred to the first judgment, my lord, the Jaggo versus Union of India.
Yes.
My lord, the next judgment in this compilation is Sripal versus Nagar Nigam Ghaziabad, my lord.
In this judgment, in para 10 and 12, correct? In
previous judgment, my lord, I read 10, 12, and then 19,
26
till 27, my lord.
Okay, next judgment.
Next is Sripal, my lord. This is of January 25.
Sripal?
What is the title?
Sripal versus Nagar Nigam.
Calcutta, Supreme Court, 2025.
Yes.
Yes.
This is judgment delivered on January 31st, 2025, my lord.
Paragraphs?
I'll refer to para 15 and 17, my lord.
Only 2 paragraphs.
14 onwards, my lord. 14 till 17, my lord.
Okay. Yes.
Para 14, my lord. The respondent employer places reliance on Uma Devi to contend that daily wage or temporary employees cannot claim permanent absorption in the absence of statutory rules providing such absorption. However, as frequently reiterated, Uma Devi itself distinguishes between appointments that are illegal and those that are irregular. The latter being eligible for regularization if they meet certain conditions. More importantly, Uma Devi cannot serve as a shield to justify exploitative engagements persisting for years without the employer undertaking legitimate recruitment.
Given the record which shows no true contractor-based arrangement and a consistent need for permanent horticulturist staff, the alleged asserted ban on fresh recruitment, though real, cannot justify indefinite daily wage status or continued unfair practice. It is manifest that the appellant workmen continuously rendered their services over several years, sometimes spanning more than a decade, even if certain muster rolls were not produced in full. The employer's failure to furnish such record, despite directions to do so, allows an adverse inference under well-established labor jurisprudence. Indian labor law strongly disfavors perpetual daily wage or contractual engagement in circumstances where the work is permanent in nature. Morally and legally, workers who fulfill ongoing municipal requirements year after year cannot be dismissed summarily as dispensable, particularly in the absence of a genuine contractor agreement. At this juncture, it would be appropriate to recall that broader critique of indefinite temporary employees practice as done by recent judgment of this court in Jaggo of Union of India in the following paragraph. The Jaggo is the previous judgment I referred to. The pervasive misuse of temporary employment contracts as exemplified in the case reflects a broader systemic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy had led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear an even greater responsibility to avoid such exploitative employment practices. When the public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but it sets as concerning precedent that can erode public trust in governmental operations. It is disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. Misuse of temporary labels. Employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual, even when their roles mirror those of regular employees. Such misclassification deprives workers of the dignity, security, and benefit the regular employees are entitled to despite performing identical tasks. Arbitrary termination. Temporary employees are frequently dismissed without cause or notice. As seen in the present case, this practice undermines the principles of natural justice and subjects workers to a state of constant insecurity, regardless of the quality or duration of their service. Lack of career progression. Temporary employees often find themselves excluded from opportunities for skill development, promotions, or incremental pay raises. They remain stagnant in their roles, creating a systemic disparity between them and their regular counterpart, despite their contributions being equally significant. Using outsourcing as a shield, institutions increasingly resort to outsourcing roles performed by temporary employees, effectively replacing one set of exploited workers with another. This practice not only perpetuates exploitative but also demonstrates a deliberate effort to bypass the obligation to offer regular employment. Denial of basic rights and benefits. Temporary employees are often denied fundamental benefits such as pension, provident fund, health insurance, and paid leave, even when their tenure spans decades. The lack of social security subjects them and their families to undue hardship, especially in cases of illness, retirement, or unforeseen circumstances.
Now 17.
But 16, there's a comments on the High Court judgment, and 17 is the main paragraph. In light of these considerations, the employer's discontinuation of the appellant workman stands in violation of the most basic labor law principles. Once it is established that the services were terminated without adhering to sections so and so of the Industrial Disputes Act, and they were engaged in essential perennial duties, these workers cannot be relegated to perpetual uncertainty. While concerns of municipal budget and compliance with recruitment rules merit consideration, such concerns do not absolve the employer of statutory obligation or negate equitable entitlements. Indeed, bureaucratic limitations cannot trump the legitimate rights of workmen who have served continuously in de facto regular roles for an extended period.
In this case, they're working for how long?
98. Since 1998.
If you work 1998?
8 years, my lord.
In this case, my lord. But there are other reasons also. But next is Dharampal, my lord. This is of August.
Dharampal is the
Dharam Singh,
watershed judgment, correct?
Yes, ma'am.
1 second, I just. Okay. Dharam Singh.
In 2025.
That's very Kamnar consistently has distinguished Uma Devi.
And that was required, my lord.
Depends which side you're on.
Yes.
That's the only thing. Yes. If you were for the union, you would have said otherwise.
My union doesn't do all this, my lord.
Yes.
No regulation cases come ever, my lord, for union.
Yes.
I'll read para 11, my lord.
Which para are you referring to? Para 11?
Para 11 and then 17, 18, 19, my lord. And 20.
Yes.
Para 11. Furthermore, it must be clarified that the reliance placed by the High Court on Uma Devi Supra to non-suit the appellant is misplaced. Unlike Uma Devi, the challenge before us is not an invitation to bypass the constitutional scheme of public employment. It is a challenge to the state's arbitrary refusal to sanction post despite the employer's own acknowledgement of need and decades of continuous reliance on the very workforce. On the other hand, Uma Devi Supra draws a distinction between illegal appointments and irregular employment engagement and does not endorse the perpetuation of precarious employment where the work itself is permanent. The state has failed for years to put its house in order. Recent decisions of this court in Jaggo and Sripal have emphatically cautioned that Uma Devi cannot be deployed as a shield to justify exploitation through long-term advocacy. The use of outsourcing as a proxy or the denial of basic parity where identical duties are exacted over extended periods. The principles articulated therein apply with full force to the present case. The relevant paras from Sripal have been reproduced hereunder. I may
So
skip
reading the same judgment over and over again.
Yes, my lord. So I may skip this part, my lord.
And 17.
Para 17, my lord.
Yes.
Para 7. Before concluding, we think it necessary to recall that the state, here referring to both the union and the state government, is not a mere market participant but a constitutional employer. It cannot balance budgets on the backs of those who perform the most basic and recurring public functions. Where work recurs day after day and year after year, the establishment must reflect the reality in its sanctioned strength and engaged practices. The long-term extraction of regular labor under temporary labels corrodes confidence in public administration and offends the promise of equal protection. Financial stringency certainly has a place in public policy, but it is not a talisman that overrides fairness, reasons, and duty to organize work on lawful lines. Moreover, it must necessarily be noted that advocacy thrives where administration is opaque. The state government must keep and produce accurate establishment registers, muster rolls, and outsourcing arrangements, and they must explain with evidence why they prefer precarious engagement over sanctioned post where the work is perennial. If constraint is invoked, the record shows that the alternatives were considered, why similarly placed workers were treated differently, and how the chosen course aligns with Article 14, 16, and 21 of the Constitution of India. Sensitivity to the human consequences of prolonged insecurity is not sentimentality. It is constitutional discipline that should inform every decision affecting those who keep public offices running. Having regard to the long undisputed service of the appellant, the admitted perennial nature of their duties, and the material indicating vacancies and comparative regularization, we issue the following directions. 1. Regularization and creation of supernumerary post. All appellants shall stand regularized with effect from 24/4/2002, the date on which the High Court directed a fresh recommendation by the Commission and a fresh decision by the state on sanctioned post for the appellants. For this purpose, the state and the successor establishment, that is UP so and so, shall create supernumerary post in the corresponding grades, cadres, class 3, driver and equivalent, and class 4, peon, attendant, guard or equivalent, without any caveats or preconditions. On a regulation, each appellant shall be placed at not less than the minimum of the regular pay scale for the post. I can skip this part, my lord. This is a case specific, my lord. Para 20. We framed these directions comprehensively because case after case, orders of this court in such matters have been met with fresh technicalities, rolling reconsiderations, and administrative drift, which further prolongs the insecurity of those who have already labored for years on daily wages. Therefore, we have learned that justice in such cases cannot rest on simplicity directions, but it demands imposition of clear duties, fixed timelines, and verifiable compliance. As a constitutional employer, the state is held to a higher standard, and therefore it must organize a perennial workers on a sanctioned footing, create a budget for lawful engagement, and implement the judicial directions in letter and spirit. Delay to follow these obligations is not very negligence, but rather it is a conscious method of denial that erodes livelihoods and dignity of these workers. The operative scheme we have set here, comprising of creation of supernumerary report, full regularization, subsequent financial benefit, and a sworn affidavit of compliance, is therefore a pathway designed to convert rights into outcomes and to reaffirm that fairness and engagement and transparency in administration are not matters of grace but obligations under Article 14, 16, 21 of the Constitution of India.
Please my friend to read paragraph 4.1 also. So then
you can read that. Your tongue comes.
Complete the case also.
Yes.
4.1 of this paragraph.
Clear picture.
A clear picture will be there.
Then I'll refer to Vinod, my lord. I'm skipping Nilima. I'll refer to Vinod, my lord. Vinod Kumar and others. Was this?
Vinod Kumar?
Yes, ma'am.
Yes. Yes.
Para 5, 6, and 7.
Yes.
Para 5. Having heard the arguments of both the sides, this court believes that the essence of employment and the rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. The continuous service of the appellants in the capacities of regular employees performing duties indistinguishable from those in permanent post and their selection through a process that mirrors that of a regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Moreover, the appellant's promotion process was conducted and overseen by a departmental promotion committee, and their sustained service for more than 25 years without any indication of the temporary nature.
25 years.
Well,
Yes.
the petitioners also more than 15 years, some 20, 22 years also.
Yes.
Without any indication of the temporary nature of their roles being affirmed or the duration of such temporary engagement being specified merits a reconsideration of their employment status. The application of the judgment in Umadevi by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their services. The reliance on procedural formalities
Same
at out.
as the same. Yeah.
Well,
Yeah.
I'll read para 7.
Yes.
The judgment in Umadevi also distinguishes between irregular and illegal appointments, underscoring the importance of considering certain appointments, even if it were not made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they had followed the procedure or regular appointments, such as conduct of written examination or interview, as in the present case. The Umadevi is quoted only para 53.
The exception paragraph.
Yes, ma'am.
Yes.
Now I'll refer to some High Court decisions, my lord.
Yes.
Following this series of judgment, Dharam Singh and Jaggo, my lord. First is Calcutta High Court, my lord.
Just 2025 SC Online.
2025 SCC Online Cal
5293. Paragraph.
29, 30, 31, 32 and 37. 29, 30, 31, 32.
29.
30, 31, 32.
30.
31.
31.
32. And 37. The concluding part then.
Okay.
And 29, the Jaggo has been quoted, my lord.
Jaggo led the way, I think.
Yes, my lord. Jaggo, Sripal and Dharam Singh, my lord. These are the three. My lord, para 29, Jaggo has been quoted, my lord. Para 30, Sripal has been quoted, my lord. I'll read 30 and 31, my lord. The Honorable Supreme Court in the case of Sripal observed that the judgment of Uma Devi cannot be used as a seal to justify exploitative contractual appointment that continue for years without the employer initiating a legitimate recruitment process. This view has been affirmed with the subsequent decision of Vinod Kumar. 31 Mala. A concerning trend has emerged wherein government institutions, in an apparent attempt to evade liabilities relating to pension and promotional benefits, are increasingly resorting to contractual part-time outsourcing service or project-based appointment, even though the duties assigned to such employees are perennial in nature. Many of these individuals have entered uninterrupted service, have rendered it in uninterrupted service for well over a decade. Support for this view cannot be obtained from the decisions in Jaggo so-and-so, so-and-so. 32. In the case of Jaggo Supra, the Honorable Supreme Court, taking note of the fact that the initial engagement of the appellant had been labelled as contractual, observed that they had been rendering daily and continuous service over an extensive period spanning decades. The court further noted that the nature of their duties was fundamental to the functioning of the office and closely resembled responsibilities typically associated with the sanction post. In light of these factors, the court directed the regulation of their service. It was further observed that the High Court had placed undue emphasis on the initial nature of the appellant's engagement, overlooking the substantive character of their long-standing service. Then para 37. The direction to regularize within 12 weeks' time. Next, I am referring to Delhi High Court.
Yeah, Jaggo also comes.
My lord, these are all post-Jaggo, my lord. Para 17 and 18.
Para?
17 and 18.
Subhash Chandra.
Subhash Chandra.
This is Subhash Chandra.
Yes, my lord. This is a division bench of Calcutta. Para 17.
That is right. What is judgment observes. Now, if these judgments are now we have to balance them against Uma Devi. They've radically changed the entire conceptual jurisprudence with regard to.
My lord, what Supreme Court tried to say, my lord, Uma Devi is interpreted wrongly, my lord. In fact, Uma Devi created a restriction on government to appoint, my lord. That you don't appoint anymore.
You don't appoint anymore. And within 6 months you
my lord.
Stop.
And now they appointed, my lord, so they have to bear the brunt of that, my lord. They violated Uma Devi, not us.
What is appointments of post Uma Devi?
Yes, post Uma Devi.
In these
most of the cases
petitions.
Most of the cases are post Uma Devi. But some maybe before that, my lord. We will segregate that, my lord.
But because even there are executive instructions issued also that there shall be no more appointment ad hoc.
Yes, my lord.
But that's continued. So if they they can't harness in their own.
My lord, that is what Supreme Court has tried to say, my lord.
These poor people made to suffer.
Yes, my lord. Government should suffer for that, my lord, for appointing.
Yes.
Not the appointees, my lord. And para 17 as read, there is some relevance, my lord, of this.
Yes.
The position in law now has changed radically with the judgment of the Supreme Court in Jaggo, Sripal in its comparatively recent decision in Din Garg versus so-and-so. This court has attempted to trace the trajectory of evolution of the law relating to regularization of casual employees, daily wages, contractual employees and the like, and has, after referring to the judgments in state of Karnataka so-and-so, culled out the following principles. Long and uninterrupted service rendered for 10 years or more. Well, I'm stressing on this 10 years, could not be brushed aside by leveling the initial employments as part-time or contractual. Importantly, the Supreme Court held that essence of their employment had to be considered in the light of their sustained contribution, the integral nature of their work, and the fact that no evidence suggests their entry was through an illegal or surreptitious route. The passage denotes an important development in the law by which the Supreme Court has effectively lifted the veil of the nomenclature conferred to the appointment of the employees. The Supreme Court had held that it is not the nomenclature of the appointment which is of relevance, but the nature of the service rendered by the employee. The nature of the service by the employees would in turn determine the actual nature of their appointment. The Supreme Court has identified for this purpose the relevant considerations as being the sustained contribution of the employee, the integral nature of the work, whether any evidence exists to indicate their entry was through any illegal or surreptitious route, whether the employee had been engaged in performing essential duties indispensable for the day-to-day functioning of the office on a daily and continuous basis over an extended period. The responsibilities undertaken by the employees had to be treated as akin to those typically associated with sanctioned posts. In such circumstances, it could not be brought to the contended by the establishment that the posts held by the employees on ad hoc, part-time, casual basis were not regular posts, as the nature of work rendered by the employees. But I'll pause here, my lord. In our case, my lord,
yes,
in a majority of the cases, the posts are sanctioned, my lord. We are
sanctioned posts.
all against sanctioned posts, my lord.
Is there a question of ad hoc or perennial or just temporary?
Those are all sanctioned posts, my lord. If I take out
contingent.
If I take up the first case itself, my lord, the lead case, my lord, he is appointed against vice somebody retired. So it is against sanctioned post, my lord.
Now, who appointed? Head of the department.
Head of the department.
Yes. But you see, Mr. Karajan, I know why the government resorts also. Sometimes there's an urgent requirement. They have to make do. There's that is the thing. But then how do we can't abuse the services or abuse the process also. Where do we strike the balance?
And my lord, I'll say, I'll submit, my lord.
One thing also which comes to mind is that, you see, by appointing people directly against, now what about other people, there are how many unemployed waiting for appointment?
No, my lord, kindly see, majority of the cases, my lord, those are recruitments against state quota, my lord. My lord, the incumbents were selected through an advertisement for undergoing course, my lord. May I take item number 1, my lord? I'll just point out how the things are done, my lord. I'll just point out the facts, my lord. First item,
yes, 438.
438.
Yes, I have 438.
Well,
does it matter? You see, executing a bond doesn't mean that automatically also should be.
But in normal course, no, my lord. But the law says that the liability is on the bondee, my lord. Government is not liable to call him for employment, my lord. But my lord, once he has been appointed and rendered service for 10, 15, 20 years, my lord, then he acquires right.
Yes.
Now, my lord, page 18 is the advertisement, my lord.
They are which people? They are sericulture.
The sericulture, my lord. No, this is education department.
Pharmacy. What is
they are weaving inspector, my lord.
Where's weaving inspector?
Page 18, lord, so kindly see. The government of Meghalaya is pleased to nominate the following for diploma level engineering pharmacy courses during 2000-2001 at the Institute State Directorate.
Pharmacy is one, not weaving.
No. It's a joint combined.
My lord, because it is a joint, my lord, so kindly see.
Yeah. Where's written weaving?
My lord, they only mention about the degree, my lord. It's a diploma.
So written here, engineering, pharmacy, merit list.
My lord,
the names are here.
Page 19, kindly see, my lord.
The names are here.
Page 19, lord.
Where are the names?
Page 18, his name is there, my lord. In the second column, engineering waiting list, general category. Then Khasi and Jayanti category, my lord.
Waiting list?
In the second column, serial number 11 is his name, my lord.
But he's an engineer.
Well, he has undergone
Did he get a diploma in engineering or in weaving?
Textile technology, my lord.
That comes in engineering?
Yes, my lord.
Okay. We just have to understand clearly.
Yes, my lord. Well, page 19 is the letter from Government Department of Higher Technical Education to the Director Technical Education, Government of Tamil Nadu, Chennai. Admission of students of Meghalaya for undergoing study of diploma level course in engineering, pharmacy, so and so, against the seats reserved by the Government of India. Now, my name is there, my lord. Then it says, my lord, the branch of studies textile. Then it says, my lord, I would therefore request you to kindly allocate the name of the college institute and arrange admission of the above course of study and arrange for hostel accommodation. While sending the candidate to the prospective college institute admission, the college institute may be asked to intimate the date of joining to the directorate. Further, any case of discontinuance. So basically by this letter, my lord, State quota has been sent. This is a bond signed, my lord, page 20, before sending him.
So where's the appointment?
My lord, after bond, my lord, then he obtains the degree, my lord. Page 25 is the degree, diploma in textile technology.
Yes, he's a trained person. Yes. First class.
Now appointment order is page 28, my lord. May I read, my lord? Few points are important here. Subject to discharge without notice and without assigning any reason thereof, Sri so and so stipendiary had successfully completed 3 years diploma in textile engineering from Institute Palachipalli Technology, Chennai, is allowed to officiate temporarily. Now, my lord, officiate word is used, is not ad hoc word used, my lord. So that's one aspect, my lord.
That was made 2011.
My lord, officiate temporarily and until further orders for 58 days, so and so, in the proper pay scale is given, my lord. It's not a contractual salary of 10,000 or lump sum figure, my lord. Then it says, my lord, plus other allowances as admissible under the existing rules with effect from the actual date of joining. Why is Srimati M. Coach retired? So again, that indicates, my lord, it is against a sanction post, my lord.
Yes.
Now, my lord, kindly see at the bottom, my lord, serial number 3.
Yes.
It's a mark to Sri P.K. Chalam through the petitioner, my lord. It says he is requested to apply to the Shillong MPSC as soon as the post of weaving inspector is advertised by MPSC, and is liable to be discharged in terms of the above orders, as this appointment is temporarily in nature only, unless, now this has to be interpreted, unless the recommendation of the MPSC for the post is delayed.
Yes.
He should produce the medical. Now MPSC, according to my instruction, has never advertised the post till now, my lord.
Never advertised.
Never advertised, my lord. And the appointment clause itself says, unless the delayed by MPSC. So that means it is not temporary.
Yes.
And it was against a proper pay scale, my lord.
No, I've seen that. Yes.
My lord. The next page, my lord, lords will see. This is a contribution to NPS, my lord.
Service book was opened.
Service book opened. We have not annexed because it becomes very bulky, my lord. But if necessary, we can produce. Now, this is a national pension scheme, my lord. Kindly see. On the right hand top, my lord, there is a box. DDO name. District Handloom Officer, Dilma, North Garhils, Rachulpada. He is the drawing disbursing officer. And in the table below, my lord, you will see money is paid by Directorate of Accounts and Treasuries, Meghalaya, my lord. In the table below, my lord. Uploaded by.
Yes, yes.
So, my lord, NPS deducted from our salary by DDO, my lord, and deposited in whatever government fund is there, my lord. Now, my lord, kindly comes page 32, my lord. Leave for undergoing treatment, my lord. Ex post facto approval is hereby accorded to the treatment of Sri so and so. His age, my lord?
He's got congestive cardiac failure.
45 years.
He's 45 now.
Okay.
Page 16, my lord.
Yes.
So, allowed medical leave, my lord.
And even given reimbursement?
Yes, my lord. Serial number, medical bills duly countersigned amounting to rupees so and so, only along with other are enclosed herewith in favor for necessary action. 3,81,000. Now, next page, my lord, he is allowed to undergo further training, my lord, while in service.
What's Jacquard? GAC, anyway.
Jacquard, program Jacquard.
Yes.
Yeah. So, my lord, we have next one order passed by lordship. I'll come to this order later on, my lord.
Yes.
Now, the impugned the SOP, my lord, page 44, my lord. Kindly see.
That's important.
My lord.
What does it say? I'm not really.
Yes, madam.
applied my
I'll
mind
read
to
this.
it.
It's a two-page document
Yes.
only. This is dated 25th September 25. Standard operating procedure for filling sanction posts occupied by ad hoc appointees. So they admit, my lord, that these are sanction posts occupied by ad hoc. So we are on a better footing than the cases before the Supreme Court, my lord.
Yes.
Appointed after 31/12/17 and grant of one-time age condonation certificates. Preamble. The Cabinet in its meeting held on 26 August 25 considered the issue of a large number of sanction posts in government departments being occupied by ad hoc appointees appointed after the cutoff date of 31st December 2007. Now, I will kindly note the word used is only ad hoc. They are not talking about contractual, they are not talking about officiating, they are not talking about any other post, my lord. Only, I've gone through the entire document, they are only talking about ad hoc. So how far our appointments can be considered as ad hoc, my lord? Because ad hoc, your lordship aware, limitation of function regulation, my lord, that only creates a provision for ad hoc appointment. We are not appointed under those limitation of function regulation, my lord. So being occupied by ad hoc appointees appointed after the cutoff date of 31st December 2007 and approved the proposal to conduct fresh recruitment to these posts through the competent recruitment agencies. Successive government instructions since 1978 have prohibited ad hoc appointments, again ad hoc, of outsiders who were not recruited by MPSC, DSC or any other duly constituted recruitment board committee. Despite these instructions, ad hoc appointments continued in several departments, leading to long-term occupation of sanctioned posts in contravention of recruitment rules and the state reservation policy. The Cabinet has earlier approved regulation only in respect of ad hoc employees appointed on or before 31st December 2007, subject to strict conditions. Appointees made after the cutoff date are not eligible for regulation. Based on preliminary information compiled by the Personnel and ARB Department from the inputs received from the various departments, about 1514 ad hoc employees appointed after 31/2007 are presently occupying sanctioned posts. This figure is indicative only and subject to verification by the respective administrative departments. The actual numbers may be higher once comprehensive department-wise verification is completed. All such sanction posts are required to be filled through open competitive recruitment conducted by the competent recruiting agency in accordance with the provisions of the Constitution and the applicable recruitment rules. To ensure that the incumbent ad hoc employees are not unfairly excluded from participation merely on ground of age, a one-time relaxation of upper age limit will be operationalized through the issue of a certificate of age continuation valid for 1 year. Purpose of this office memorandum. The office memorandum sets out the standard operating procedure to A. Identify sanction posts occupied by ad hoc appointees appointed after 31/12/2007. Conduct recruitment to such posts through MPSC, DSC Recruitment Board Committee. Provide for certificate of age continuation for overage ad hoc employees. Ensure completion of all such recruitments within 1 year in a transparent and time-bound manner. Certificate of age continuation eligibility. All ad hoc employees appointed after 31/12/2007 against sanctioned posts who have crossed the prescribed upper age limit for entry into government service. Issuing authority, the personnel and ARB department shall issue the certificates on the basis of verified lists submitted by the administrative departments. Validity. Each certificate shall be valid for a period of 1 year from the date of issue. Scope. Holders may apply for all recruitments advertised by MPSC, DSC, recruitment boards and departmental selection committee during the validity period. Recruitment agencies shall accept the certificate as proof of age relaxation subject to the candidate meeting other eligibility limitations. The concession is a one-time non-presidential measure. Certificates are non-transferable and automatically lapse on expiry of the validity period. No revalidation or reissue will be permitted. Standard operating procedure for recruitment. Identification of vacancies. All department officers shall prepare and forward verified list of all.
I started.
Yes, my lord.
You started. Verified list. Okay.
Within 30 days of this OM. Roster compliance. Roster clearance must be obtained from the personnel ARB department before requisition is sent to the recruiting agency. Recruitment agency action. Advertise the vacancy within 45 days of receipt of requisition. Complete written screening test within 120 days. So timeline is given, well. Completion deadline. All recruitment shall be completed within 1 year from the commencement.
But as SOP, they are contemplating to advertise the entire sanction post available. So notwithstanding, so ad hoc, so they are
treating all and sundry as ad hoc, my lord. Now ad hoc has some legal meaning. Who are called ad hoc and who are called whether people appointed through a proper selection process, my lord, for undergoing training in nursing or technical paramedics, my lord, can they be treated as? Is it a completely backdoor entry, my lord? That's one question to be answered, my lordship.
So all these petitions are ad hoc. There's no.
Well, we are saying because if I take a lordship to GNM, ANM appointment order doesn't say it's ad hoc, my lord.
Okay, now leaving those aside, we left that aside. But I mean, all the other petitioners were here. They're all ad hoc. There's no.
They've been made under the purview of this.
My lord, they've been sought to be brought under the purview of this SOP, my lord. My lord, some of them they said, my lord, they never knew that they are ad hoc.
No, that's what this is striking my mind.
They are paying GPF, my lord. They are paying NPS. They are going on medical leave. They are getting study leave, my lord. They are getting annual increments. They are getting pay commission.
Open a service book also.
Open service books, my lord.
All of them.
Most of them, my lord. Almost all of them, my lord. And now to label them as temporary ad hoc.
Yes. Okay. Any of these replays came before this court earlier on an earlier occasion? None of them.
None of them, my lord. And earlier, one batch of them they came. I've annexed the order, my lord. Your lordship allowed, though they have not complied with that. I think contempt is pending. Mr. Philemon Nongres filed his case, my lord.
What's the order?
That's it is in the petition, my lord. At page 37.
Hmm. Yes.
So they are from the same department, so selected in the same way.
So now, from the compilation again, that's it. You're finished.
No, I'll add two or three more reasons. Similar line, well, they've relied on Jago and Sripal only.
They are high courts.
The high courts.
Kerala. Jaykumar.
Well, I was referring to Delhi High Court, Malad. Subhash Chandra. Para 17, I was reading sub-para.
Yes.
Sub-para 3 I was reading.
In such circumstances?
Yes, madam. It could not be sought to be contended by the establishment that the posts held by the employees on ad hoc, part-time, casual basis were not regular posts, as the nature of work rendered by the employees was perennial and fundamental to the functioning of the office. Significantly, the Supreme Court holds that the recurring nature of these duties necessitates their classification as regular post, irrespective of how their initial engagements were labeled. Subsequent outsourcing of the same task to private agency fortified the conclusion that the services rendered by the employees were inherently needed by the establishment and that the work undertaken by them was neither temporary nor occasional. Consistent, satisfactory performance by the employer over a long period of time further solidifies their claim for regularization. Where the job rendered by the employees was menial in nature, such as cleaning, sweeping, dusting and gardening, the establishment could not seek to contend that the employee did not possess the necessary educational qualification for the post. The educational criteria were never central to the engagement by the employee or to the performance by them of their duties. Insisting on formal educational requirement would amount in such circumstances to an unreasonable hurdle. Wherein in such circumstances the employees' roles were essentially indistinguishable from the role of other regular employees, the employees had rendered sustained service over extended period and there was no adverse report regarding the performance. Equitable treatment and regularization of the service of the employees was warranted. Denial of such regularization amounted to manifest injustice and required rectification. The decision in Umadevi did not intend to penalize employees who had rendered long years of service, fulfilling ongoing and necessary functions of the establishment. It was intended to prevent backdoor entries and illegal appointments which circumvented constitutional requirements. Where the appointments were not illegal but possibly irregular, and where the employees had rendered sanctioned functions continuously for a long period, the need for a fair and human resolution becomes paramount. Thus held the Supreme Court, prolonged, continuous and unblemished service performing tasks inherently required on a regular basis over the period transformed what was initially ad hoc or temporary into a scenario demanding fair regularization. Where the initial appointment of the employee was termed temporary, but the employee had performed the same duties as performed by regular employees over a considerable period, procedural formalities could not be used to deny regularization by service. The court was required to look beyond the surface level of the workforce being undertaken by the employee and to consider the realities of the employment, which included continuous long-term service, indispensable duties, and absence of any malafide or any illegalities in their appointments. Refusing regularization to such employees merely because the original terms of their employment did not explicitly provide for regularization, or because an outsourcing policy had been belatedly introduced, would be contrary to principles of fairness and equity. Among the ways in which the temporary employees were exploited were misuse of temporary labels, arbitrary termination, lack of career progression, using outsourcing as a shield, denial of basic rights and benefits. Umadevi was intended to curtail the practice of backdoor employment and ensure that appointments adhere to constitutional principles. It was regrettable that Umadevi was being interpreted and misapplied to deny legitimate claims of long-serving employees. The judgment distinguished between illegal and irregular appointments. It provided for regularization as a one-time measure of employees who were engaged in duly sanctioned posts, had served continuously for more than 10 years, but whose initial appointment was irregular. In fact, it lacked adherence to procedural formalities. Applying these principles to the fact of the present case, we find that the entitlement of petitioners to regularization cannot be disputed, and the respondents themselves were considering them for regularization. They had been appointed against sanctioned posts and vacancies are available. They have continued from the time of their appointments as leave substitutes for 25 to 27 years and even after their conversion to daily wage employees for over 18 years as on date. There is no complaint about their work. The job is perennial as they are working as chowkidars, and the very fact that they are having served the MCD for so long is a testimony to their continuous requirement. The additional affidavit, so Para 19, the concluding part. Inasmuch as the petitioner's entitlement to regularization is undisputed, the court applying the law laid down in Jago case holds the petitioner to be entitled to regularization of the post occupied with them.
And the others, JNK, all same line.
Same line, well.
Karnataka.
Well, I'll just mention the para number. This next one is para 16 and 17, well, JNK.
JNK judgment. This is para
16 and 17.
Which one? Title, because I don't have name now.
Union Territory of JNK, that's Robin Call.
Kerala.
Para 20 minutes.
Karnataka.
Para 14.
Yes. Anything else?
The regular appointment is done as per rule. So we have not advertised the post in all the same appointment order.
So, this is primarily the law, the way it is.
You can make a joint argument.
Normally, the facts are quite different in every case, my lord.
That is what I was thinking. Because then, if we're looking at the length of service and the nature of engagement, then we have to segregate them.
That is one aspect. My lord, the second aspect, and what is more startling is, in case of ANM, GNM, there is a regularization order, my lord, by DHS. And there's a confirmation order, my lord.
That will take separately.
My lord.
That would not call.
But here, even in
they
these,
have not been appointed under the district selection committee under the statutory rules, my lord.
That's all right.
So we'll have to look into those aspects.
That's why we're saying we're segregating that.
I'm trying to.
We are trying to.
Yes, my lord. They
segregate those
have
ENM and JNMs and
separately.
paramedics.
But your lordship will hear the matter in toto, and then your lordship that will because only.
No, that's why we'll hear that secondly. We'll hear this matter first.
Yes.
And then we will also, then
because it will go in one go. It will be all matters will be over, my lord. Because some of the issues will be overlapping. So far,
no overlap, no doubt. But the situation of the petitioners will be different.
Because my argument will be short and crisp on the issue that all the
will be short and crisp.
The short will be, my lord, that what I say is that, my lord, your lordship will, as according to me, my lord, what your lordship would be required to examine whether these appointments are irregular or illegal. That is first requirement, because if these appointments are illegal, they are not entitled to regularization. I will distinguish all I will distinguish all the judgments which my friend has cited. Workman, your lordship will examine Workman, all those 98. I will see. And all those are in the context. None of the judgments have said that Uma Devi is a bad law. Law declared by Uma Devi is not a good law. That Uma Devi is...
No, that has been submitted by the Senate, by the, Dr. Mozika also, that look.
Yes.
It's not Uma Devi is a bad law. It's just that what did Uma Devi postulate?
Yes.
And
so,
after the postulation given in a prescription given Uma Devi, what has happened?
Yes, ma'am.
And that is why the exemption 53, what has happened and what is the situation? How did the courts deal with the situation after Uma Devi? This is more, this is a situation that is what...
No, these are post-Jago. These are post-Jago.
No, this is post-Jago, post Uma Devi.
From 2006 to
the watershed.
Yes. No, Jago is completely distinguishable, my lord.
That's what this court is saying. There's other judgment from that Kishan.
Yeah, I have those judgments.
Kishan come from Karnataka, not cited, but they have sought to carve out exceptions from Uma Devi using
paragraph. In fact,
but in this case, there has been the radical shift after Jago with regard to how the courts have perceived.
No, your lordship, Uma Devi has already provided relief to those who have been in employment till 2000.
No quarrel with that. Only thing is that because of the situation, how the courts are molding the relief.
There is no, my lord, with greatest respect, my lord, there is no molding in the judgments. If your lordship will...
It's not molding judgment, it is the relief that's given when this situation...
Because they were all employed pre-Uma Devi for more than 10 years. In all the judgments, your lordship, 97, 98, your lordship knows. Uma Devi said all employment before they are only
Then there was other cases of exception. Exercise could be completed 6 months after Uma Devi.
Yes,
so like we carved.
This is my case. This is my case, my lord, because what my friend has read out only those portion of the judgment. Because your lordship knows that Uma Devi said this is a cut-off date. After cut-off date, there will be no regularization, and all these appointments 97, 98 are all covered by Uma Devi only, my lord. And Workman appointment. There are issues, my lord, which I will address, and I will.
But has the state look at Plan B? Plan A is SOP.
No, there are judgments.
Suppose Plan A fails. SOP fails. What is your Plan B?
No, my lord, the SOP is a watershed event for the state for two reasons, my lord. One is, my lord, if SOP is not accepted and workable, my lord, because your lordship knows that all the time, director, those who are not competent, they are giving contractual appointment, and they are giving in various districts. They give despite so many orders your lordship has seen, and they are giving contractual appointments without calling for advertisement, without inviting all those who are. So if the SOP is, we are trying to clean the mess which have been there pre Uma Devi. That is so, because now if then again after 5, 6, 7 years someone will come because I got the temporary, or 10 years give me regularization because I worked for 10 years. Appointment was given to me by a person who was not competent under the rules. No advertisement was issued. I have worked for 10 years and I have got my pension account, etc. by that person. Give me regularization. That means Article 14, 15, 16, because those who haven't got the opportunity. Because I was close to the director, I knew the director, I got the appointment, my lord. But what about the others who did not know the director, my lord?
No, that's
advertisement,
my lord.
No, that's other matters.
So
thing is that, see.
So if there is, and in all of them, there is no advertisement, my lord. I will show that also.
No, not all. I'm not saying all. All A&M, GNM paramedics are
A&M,
advertisement, my
GNM
lord.
also, my lord. A&M, GNM, I will show also. I have got the instruction also in A&M, GNM also, my lord. Because the rule says, my lord, the rules which are in place in 2008, which says that the appointment will take place through district selection committee. That rules are there. None of them have been appointed in terms of rules. My lord, we will place all these material, my lord, before your lordship, and I'll meet the challenge which my friend has.
No, again, you have to make the
and then in one of the
make the distinction irregular and illegal.
Yes, that is the fundamental.
Not as per the rules, the rules irregular.
Yes. No,
backdoor illegal appointment.
No, because in this case,
through
my lord,
the back door, out through the back door, is like that.
No, in this case, my lord, what has happened that if there is no advertisement, and the rule and all public employment has
so you have to distinguish.
Yes,
to say that they have come through the back door.
Yeah, I will place that because they are, for example,
all the prisoners have come to back door.
Yes, my lord. First example only.
The back door.
The lords will see that person was appointed by the person in vice in retirement by director or by the without any advertisement, without following rules.
He was appointed temporarily.
Temporarily, officiating,
which was because
he was getting vacant.
Then why was that requirement not sent to the MPSC immediately?
No,
or to the DSC
because, my lord,
if the failing on whose part?
Now, so if there is a failing on the part of the official, whether they can take advantage of that failing, my lord, under the constitutional scheme, under the statutory rules, if the official has not followed the statutory rules, constitution, and this person also knows that officiating, MPSC, person knows that I am not a permanent, I have not come through the direct competitive examination. If he is there and it is temporary and he is not regularized, he is entitled to be regularized, my lord. These two, three requirement of public.
Have to make
yes, we will do that. And we'll
continue tomorrow.
Yes, we can do it, but after 2, I am some difficulty, my lord. After 2, because bench we have now musical chairs, my lord.
Tomorrow, I don't think we'll have musical chairs.
Then Monday, you lord.
Monday, you lord. Short submission, lordship. Lordship, just to reiterate the points advanced by one senior lordship.
Which senior?
Both senior.
Lordship, the literal meaning of the word ad hoc, lordship, as I understand, is work specific in a short period of time. This is a Latin word, lordship, within command for this. But the work carried out by the petitioner is perennial nature, lordship, and they have been allowed to continue for a continuous period of time.
That is
no
trappings of all the. See, there's no. See, that is not in dispute.
That is not in dispute.
All the trappings of. But now we have to look in the backdrop of what? Now we have Umadevi, we have no Jago. Jago really jagoed everything now. You can say, started. So that's the thing. Where justice become that maybe has his own concept. So we also have to, strike a balance between whether your rights and the demands of public employment.
One more aspect also is that similarly identically placed employees have been regularized by the state in the past, also in 2007 and 2022. Now the state is trying to draw a distinction post 2007 lordship, and there is no rational intelligible differential lordship in drawing a distinction into post 2007 and pre 2007 lordship.
Was this regulation done as per law?
By the cabinet lordship in 2022.
Well, that was whoever appointed prior to 2007. That's a one-time 2045,
yes,
I think.
There is no dispute. The state wants to streamline the recruitment process. It should be applied prospectively also. In future, no recruitment should be done at
They have been doing that by OMs. They have been doing memorandums repeatedly.
They have been functioning lordship, and there is a human element lordship. Law cannot be divorced from human element lordship.
See, everything is based, it's a code of equity. So,
but primarily 10 years has to be the cutoff merit somewhere. But those who have not completed maybe 10 years in some ad hoc post, my lord, as on today or as on the date of SOP, maybe they can be treated differently.
Okay, yes. Pose for further arguments on Monday is the 17th. Yes, 17th. I think we can finish it on Monday.
Yes, Lord. Yes.
Because there's some
With the difficulty, even I am facing in classifying the matters, my lord. Now, confirmation and regularization are altogether different concept, my lord. Confirmation comes when somebody is on probation, my lord. Somebody appointed on probation, then confirmation comes, my lord. Regularization is
in the states applied differently. Confirmation service comes after 10 years when you already appointed regularly in a post.
Yes, that is the.
So confirmation doesn't mean service doesn't mean like probation periods. Whether you meet the criteria, you perform well.
Then confirm normally. Then a confirmation order is issued, my lord. Well, here there is a regularization order. There is a confirmation order, my lord. And then they say no, your DHS is not a competent authority. Now your rules say the DHS is the appointing authority, my lord.
There was a case here where I carved out a distinction when a person's appointed as a poultry attendant. Then when he's promoted by a departmental promotional committee also to the post of driver and senior driver. And then when he retires, he finds out there's a substantive post of poultry attendant. So his last pay drawn as of a senior driver, which is much higher. And when he gets his pension is against the scale pay of poultry attendant. So what are you going to say about that?
Well, there's one case, my lord, is given promotion also, my lord. And they're saying
that's a promotion. A poultry attendant becomes, so what are you going to do?
That is.